respondents, and then you can introduce
Yep.
people until
Yep.
the other issues.
I need to go live for you to see me. It doesn't really help.
Morning, Your Honor. Michael Kotlarczyk from the Attorney General's Office on behalf of the respondent, Jenna Griswold, Secretary of State in her
Making
official
their
capacity.
appearances before the court.
With me at council table is Jennifer Sullivan from the Attorney General's
Nothing's
Office
happened yet.
and Deputy Secretary of State Christopher Beal.
We're all on time.
Thank you.
Mr. Hester?
Good morning, Your Honor. Scott Hester on behalf of President Trump. With me there's Mr. Chris Hallwan. I don't know if his pro copy check has been finished. Except
It has been.
It has been. So I don't expect him to talk, but he may. Mr. Jeff Blue as well, Mr. Jacob Roth, and Mr. Justin Mills.
And you had an evidentiary issue you wanted to address?
I don't think you want to address it now a little bit later. I will defer to Mr. Blue. These have those conversations with
Your Honor, I think it makes sense to just go ahead and press the ballot, and then we'll deal with these housekeeping items at the end of the day.
Okay.
It's supposed to be a short day today. If you missed my podcast from last night on the show,
Okay, we need to take
I was covering Minnesota arguments.
Some technical issues.
Minnesota oral arguments on this issue of disqualifying Trump. Some novel ideas that never came up here. Sorry for blocking.
You don't think I should blame Mr. Gessler for that, Mr. Blue? You don't think
One
I
of
should blame
the
Mr. Gessler
stupid
for
jokes that the judge told.
I try to take responsibility for myself.
Not funny. I don't think. Today we're supposed to have only one witness.
Your Honor, while we're doing this, you had, I think you had mentioned that the Denver guest Wi-Fi was not a good Wi-Fi for us. Is there another network we can use?
No,
Okay.
I just meant that if you bring your own, it usually works better than the guest.
We're supposed to be an expert witness. Expecting the testimony to last like 2 hours. I don't know how long cross will last, but we'll see. And then we'll wait. I thought the Minnesota arguments were really interesting. Some novel things came up there, which I hadn't really considered. They want to get him off now here in Colorado. They're pressing forward this emergency so he doesn't go on the primary ballot. And one of the arguments that Trump's attorneys made yesterday was, okay, what is a primary? A primary is basically an internal caucus, the Republican caucus trying to decide who we're going to rally behind, who's our guy. That's not something that's for the Secretary of State to determine. It's almost like the Secretary of State, they're supposed to oversee the state, not the Republican Party, which is a political thing. So if it's a political thing, why is the state getting involved in determining who can come forward from the Republican Party? It's a really interesting thought. And then they said in the general election, the power of the state is far more limited. And it is far more limited because it doesn't make any sense to say that, well, Minnesota can't really pick that the Republican Party wants to put forward what the Republican Party wants to put forward. It doesn't seem like it's a state issue that there should be like different people. Well, in this state, there is no one from the Republican Party because the Attorney General, the Secretary of State of Tennessee doesn't recognize Biden as being able to be eligible because they say he's incapacitated.
Take it a little longer than the court reporter hoped, rather than having everybody sit in silence, staring at pressure on her. I'm gonna go off the record and, we'll come back when she's got it taken care of.
So there's with technical issues there. I just want to point this out because people say it doesn't happen. Mark Pugner saying, I've been unsubbed again. This is 4 times in 2 days. Yeah. And he's paying. He's paid for this chat. He paid to join. You can see the little S there by his name. He's a subscriber. And he's been unsubbed 4 times. That's what happens on this channel. That is the level of animus that this place shows to my. They don't want people following me. That's why you need to follow me on locals if you want to be able to actually catch my coverage of anything or where I'm appearing. You have to follow me there because you're very likely to be unsubbed. Unsubbed 4 times, he says. 4 times in 2 days. There is this deep black mark on my channel. I'm not exaggerating when I tell you I lose dozens of people. Dozens of people are unsubbed from me every day. And I've talked about this a lot. And that these trials are the only opportunity that I have to really see any growth in my channel. Because what happens is the surge of people joining when I do a trial is something. It seems like it's like they can't algorithmically figure out how to knock them off. But on a daily basis, and here's the thing, it's so hard to unsub. Like if you think about it, you probably like subscribe to like dozens of YouTube channels. What many of them might not have looked at in a year, but you still subscribe to them, right? You don't unsub from them. No one goes to the channel and says, I'm no longer a member of this channel. The only reason someone does that is they're making a statement because they're mad at someone. Right? Like they're like, I can't believe I was ever subbed to this guy who took a position I don't like on the Middle East or on abortion or some comic who said something that I thought was really terribly offensive. So I'm gonna unsub from them. Right? But in general, you're not going around cleaning off whom I sub to. No one's doing that. And it wouldn't be that like 3 of my people, 12, 15, 20 people, because every day 20 people are doing it every day, a different 20 people, because once one of them is unsubbed, they're gone. So it's got to be the next day, it's a different 20 people, a different 25 people. And yeah, I mean, that's out of when you have tens of thousands, that 20 doesn't sound like a lot. But over the course of a month, that's like 600 people. And I'm sitting there, I'm like, and then it happens month after month. So it's like, you know, I'll tell you right now, I had 92,500 subs 4 months ago, 5 months ago. I've lost 2,000 subs, just people unsubbed. It's never like 300 at a time. People do lose subs from their channels. They lose subs from their channels because they say something that ticks off their audience. And as soon as people hear about it, you'll just see a whole bunch of people that'll just sort of, I'm out of here. But they all leave in a flock. And then then some people hear about, more people hear about the terrible offense that you did. They're like, I can't believe, what were you thinking when you started shooting BBs at that nest of like baby pigeons and you killed 4 of them cackling away? I'm really not a big fan of that, Joe. Not that ever happened. And by the way, I should make a joke about that. That really never happened. I never did that. I would never do that. I actually don't. I think torturing animals is kind of a reflection of a sick mind. But the point being, yeah, you do something that your audience thinks makes you evil, stupid, or unwatchable, or an embarrassment. So you lose a whole flock at once, and then the next day you lose a smaller flock, and the next day you lose a smaller flock, and then people forget about it eventually. It's not a steady 15, 15, 15, 17, 12, 15, 17, 15. It just, that's not organic. That's YouTube unsubbing. I thank you for your dedication, Mark. Hope you find a way to stick around. Is this Colorado case a hearing or a bench trial? It is a bench trial. Just to be clear, by the way, I mean, I think they're calling it a hearing. The point is, there's no jury. if that's what you're asking. It's not it's an unusual type of action in that it's a petition. You're not coming as a plaintiff. It's not criminal like the state versus prosecution. It's rando citizen petitioning the court for relief with respect to this issue, and that the party who should it covers is the Secretary of State. So it's special. It's considered special proceeding. Worcestershire sauce. Joe is exhausted doing 3 times 3-hour show streams a day. Should I respect and subscribe, please? You tell him Worcestershire sauce. Really, what I want people to do is subscribe here. And but yeah, locals. Good logic. What you see right here. Goodlogic.local.com. That's really where I want people to follow. Because
Thank you, Your Honor. For our next witness, we would call Mr. Robert Delahunty.
Robert Delahunty. He's supposed to be an expert witness. I don't know what he's an expert on. But we'll see. Pretty sure he's an expert. See if I got the spelling right.
You raise your hand. Do you solemnly swear under the penalty of perjury that the testimony
Let's see if I got the spelling right.
is the truth, the whole truth, and nothing
He looks
but the truth?
scholarly.
Great.
He looks very scholarly.
Have a seat and just make sure to speak into the microphone.
Good morning, Mr. Delahunty. So I'm going to be asking you some questions today, and you're here. We've called you as an expert. Let me ask you, have you ever testified? Let me start with this. Could you please state and spell your name?
Yes. Robert J. Delahunty, Delahunty.
Only one L.
And Mr. Delahunty, have you ever testified in court as an expert before?
No,
Okay. Yeah. So this is your first time.
it is.
So let me start with asking you a little bit about your professional background. What's your current position? If
I want to qualify him that he is an expert.
as
Which enables
someone
him
who's
to render an
retired,
opinion.
are you involved in any law-related activities?
Well, I write articles for other story pieces on the law and public policy.
Oh.
And in June, late June, a book which I co-authored.
Talking to the mic.
Was published. It's called The Politically Incorrect Guide to the Supreme Court. So that reflects the writing that I have done
Okay.
quite recently.
Professor Delahunty, you're leaning back.
Oh, I'm so sorry.
Just maybe far from the microphone.
Okay, try to get closer. Thank you.
Yeah.
You may be able to move the microphone too, but just make sure you speak.
Can you hear now? Thank you.
Really?
Yeah, Professor Delahunty, sometimes it's a challenge whether you're supposed to answer me or look at the court when you're speaking. But since there's a fair amount of media coverage, just try and stay close to that microphone.
Crappy mics they have there.
Let me ask you to start with your legal background in
Healthy mama.
chronological
Thank you.
order. What's your education?
Well, I graduated in 1968 from Columbia University and had a summa cum laude degree there. I then won a Kellogg Fellowship from Columbia to study at Oxford University, England. I studied a subject called Grace, which consists of 2 parts, classical history and classical and modern philosophy. And I got a first-class honors in Grace.
Now they're trying to show that he's sufficiently expert that the court will qualify him as an expert, which thereby enables him to render his opinion. We should expect that the petitioners are going to argue he's not an expert and should not be qualified.
Philosophy, I was tenured at Durham University as what they called a lecturer on philosophy faculty. That was equivalent, really, of an associate professor in the United States. At that point, about 1980, I decided to return to this country and to study law. And I studied law at Harvard Law School and graduated cum laude from there. And then, this is not educational background, but it's my past. I spent 3 years on Wall Street at a law firm called Sullivan & Cromwell. And then I joined the
Great
Department
point,
of Justice,
Sandy.
the appellate section of the Civil Rights Division.
14A prevented those who
1986.
engaged and gave comfort to
And
from
then,
voting. If these cases
at
win,
the start of
Donald Trump
1989,
voters could be
at the start
banned.
of the first George H.W. Bush administration, William Barr, later twice Attorney General.
Everyone who
invited
was
me to
certainly
become a staff
present
attorney
there, charged.
at the Office of Legal Counsel in the Department of Justice. And so I began
Thank
working there in early 1989.
Do your job.
I don't remember the year, but I was eventually promoted to the Senior Executive Service in the Department of Justice. And from 1989 until 2004, I served primarily in the Office of Legal Counsel, although for about a year, I was the special
Yeah, you just
counsel
press
to the solicitor of
the join button again.
Department of
You
Labor,
unjoin,
West
like
Department of
unfollow.
Labor. He had been a college friend of mine in England. And then I
Oh, do
served,
I have the ability to unsub one of
on
you?
unpaid leave of
I can
absence,
block someone on your
but
channel.
still employed by LLC for a year
Otherwise, I couldn't unsub you.
to be a
Without
visiting
blocking.
professor at the Columbus School of Law in Washington, D.C., which is part of the Catholic University
Did I
of
really?
America. And while at St. Thomas, I was there from 2004 until the end of
Today? I'm sorry.
2020.
How did that happen?
At the end of 2020, I
I'm really sorry.
retired.
It almost never
And
happens.
now I am a fellow for the Claremont Institute Center for the American Way of Life in Washington, D.C., and do give them legal advice from time to time.
Now, they want to get him qualified as an expert in a certain area, probably related to the 14th Amendment.
Let me interrupt you for one moment. So
I'm gonna just, I think the quorum probably needs a breath. Because that was a crazy long answer. So it's just, I think it helps everybody if you. let
No,
it
it's
go
hard.
through.
It's hard to block.
may I
people.
offer that it was
You have to, like,
also
go
an
into a
erudite
special
long
thing.
answer, Your Honor.
I wouldn't, there's no button to hit to block people.
Okay. Let me ask you a little bit about your time. You said you worked at St. Thomas School of Law from 2004 to 2020. What did you do there?
I taught constitutional law in every year I was there. I'm not absolutely certain that I did or did not teach it in the year I was on, half year I was on sabbatical.
To end giving her
Constitutional
greetings
law,
to everyone this
including,
morning.
of course, the
Morning, and
14th Amendment, that in fact was the centerpiece of my teaching. And I taught public international law, and one term I gave a seminar on the law of genocide, which is international law.
Okay. During your time in any of these positions, and it looks as though you spent most of your, or a large portion of your career, large chunks at both the Officer of Legal Counsel at the Department of Justice as well as St. Thomas School of Law. Did you have an opportunity to work with historical documents?
Oh, yes, indeed.
Can you describe some of that?
Well, I could go on, I hope not too much, but let me give you maybe 3 examples. One of the first assignments I had in the appellate section of the Civil Rights Division of Justice, this would have been about 1986, was to do research into the Civil Rights Act of 1866, which is now codified as a section. I'm sorry, Ron, I'm blanking on the site. Section 1981 of Title 48 42 of the U.S. Code. And that involved research, including looking at dictionary definitions from the 19th century on the meaning of the term race.
I did miss
In
it.
connection
I'm so
with,
sorry.
An amicus brief
How
that
did I
the
do
government
that?
eventually did not file in a case called Charity
Check it back. You did.
So
Super
my
chat.
whole of the research led me to draft
I'm so sorry.
an amicus brief for the government that was never filed, but it did right at the start of my career in the Justice Department.
Yes.
Research into
That's how I swat people.
The background of the Civil Rights Act of 1866.
It's pretty cool.
More recently,
I was about to ask you for your second example.
yeah, this is a law review article I published 3 or 4 years ago, 4 or 5 years ago. I'm interested in the law in Shakespeare, and so I wrote a lengthy article about the law in his play King John. This entailed the research into the English law of intestacy and bastardy in Shakespeare's period, the Tudor period and the Stuart period. And I made quite extensive use of a database compiled by the University of Michigan, which is called Early English Books Online. It is a collection of thousands of legal and other documents, proclamations, sermons, books of the Tudor and Stuart periods. And so I did that kind of research into English legal history of the early modern period, and indeed the Middle Ages, because the play is set in the Middle Ages, on the law of intestacy and the law of legitimacy, using those historical materials which are archived at the University of Michigan. And if I'm going to give another example.
Yeah, let's do one more example and then we'll move on.
Some years ago, in the Cornell Law Quarterly, Law Journal, I published an article on declaration of war clause of Article 1 of the Constitution, and I did primary research into primary materials from English law, English legal cases. I think it was prize law from the middle of the 18th century, consulting the original case materials.
Okay. Have you written any pieces or articles involving the vice president and the electoral count?
Yes, in 2022, along with my often co-author John Yu, who is a chair professor of law at the University of California at Berkeley, we published an article on the 12th Amendment and as we understood it, the constitutional authority of Congress to regulate the vote count process.
This is a question how Congress can regulate that. It's an amendment. Congress can't write a statute that's contradicting or even interpreting an amendment that changes it. And they passed a law that was basically saying vice president cannot make decisions about which electors to choose, and that his function is ministerial. And you sort of can ask the question, where does Congress have the authority? They may be right.
Your Honor,
and if they're not right, then they don't have the. It doesn't seem like they would have the authority to do that by statute.
Prepared to provide extensive testimony on Mr. Delahunty's background, but in light of your earlier ruling and to keep the proceedings moving, at this point, I would proffer Mr. Delahunty as an expert in the use of historical documents, legal historical documents, and interpretation of legal statutes arising from that historical analysis on constitutional issues.
And Your Honor, we would ask that you defer a ruling until we have a chance to explore those subjects across.
I'm gonna accept Professor Delahunty on what sounds to be a very good specific, subject, which is the use of historical documents and interpretation of legal statutes arising from historical analysis on constitutional issues. He was a law professor for 16 years and had a lengthy career before then. And obviously you can cross-examine him and I will consider that in the weight of his testimony. But at the same time, Mr. Kessler, I don't want to short circuit your examination in any way, so you should feel free to ask him whatever you want to ask him for the record.
Thank you, Your Honor. Your Honor, I would like to clarify legal interpretation of statutes as well as constitutional provisions.
Okay, I was reading from what you said.
That's why I clarified, Your Honor.
It's very important
I
the
am,
areas he's qualified in.
To statutes and constitutional provisions.
I'm accepting responsibility for the lack of clarity. And Your Honor, I would also note that we specifically proffered Mr. Delahunty as a rebuttal expert to Professor Magliocca as well. And so he'll directly address the items raised in Professor Magliocca's testimony.
Okay, well, Professor Magliocca, if I recall, was offered as an expert on on Amendment 14 and specifically Section 3. I'm not prepared at this point to designate Professor Delahunty as an expert on that specific.
They wanted to be able to say Magliocca's wrong, and here's why.
I haven't asked you to either.
Well, Your Honor, we would then seek to proffer him as an expert on the 14th Amendment, as he taught constitutional law for 16 years on the 14th, taught constitutional law for 16 years with a specific focus on the 14th Amendment.
And why don't we hear a little bit more from him on what he meant when he said that? Because most of the people, it seems like in the group who went to law school, my recollection of constitutional law was that it covered a lot.
Didn't cover
more than
14th Amendment
the
much.
14th Amendment. So let's find out what he meant when he said that.
Okay. And Your Honor, I would also note that we, to be straightforward with the court, we obviously raised a 702 objection to Professor Magliocca. And our view is that all of this, Professor Magliocca's testimony and Professor Delahunty's, is akin to legal analysis and interpretation,
Right.
which normally tends to be excluded by courts. And we understand that it's here to help you, and we understand also that you
You're a
noted,
rookie.
you recognize that there are a number of other published professors in the field that you will look to as well. So,
And just on that, and maybe this will help with your focus on Professor Delahunty's testimony. Professor Magliocca largely talked about historical interpretation. I do not think, in large part, and maybe not at all, he testified as to the law. He testified as to the original documents that he had uncovered in looking at the formation and the purpose of the amendment in the first place. And that is
Yeah, but that's not for someone to testify about. That's for you.
and I
to-
think
to
you will
come
hear
to
from
determination.
Professor Delahunty the interpretation of original documents
great.
as well.
Without, you're not
Okay.
supposed to take expert testimony, is
Why
what
don't
he's
we
saying
just
on that.
defer?
In Roe v. Wade, for example, and in Dobbs, they looked at the historical background. There's no expert witness that they focused on, finding a fact
Okay.
about
Um,
some senator
Professor Delahunty,
making a comment during deliberations
you,
about an
said you-
amendment.
Taught law school for, I believe, 16 years at St. Thomas, and that a substantial focus of your teachings was on the 14th Amendment. Could you provide some more detail on that?
Yes, indeed. I would think about half of the course consisted of a study of the 14th Amendment. I was, I think, quite unusual among American law professors in starting the course with the 14th Amendment, and that took over half of the term. Then I gave attention primarily to separation of powers in the final, let's say, 40%.
Interesting.
The
It is a
courts.
weird place to start with the
And
14th
I
Amendment.
focused on the 14th Amendment because I agree with the view that it was a second founding, constitutionally speaking, and it was also the focus of a lot of contemporary discussion and litigation, and I wanted to make sure my students were quite well aware of what it meant, what its origins were. I think, again, pretty unusual among American constitutional law teachers in discussing some depth, actually, the Dred Scott case as a background to the ratification.
That is unusual.
How parts of Section 1 of that amendment were framed against the backdrop in reaction to the Dred Scott decision. Most constitutional professors, I think, don't
Talking to the mic.
discuss the Dred Scott case.
And why did you focus? Well, what is the Red Stock case, and why did you focus on that?
The relevant part of the opinion of Chief Justice Thomas in that case was that African Americans, including those who were not held to bondage, were not and never could be citizens of the United States, and the naturalization provision, the citizenship provision, rather, of Section 1 ensures that they all were citizens of the United States, entitled to the privileges or immunities of citizens of the United States. So it helped to explicate the meaning of those parts, especially of Section 1. I taught the Coloradoans case every year. And so I'm not just focusing on the history of the framing and ratification of the 14th Amendment, but both the case law, Supreme Court case law, before it and after.
Did you also, as part of your course, introduce or teach your students how to view and interpret and analyze historical documents?
Well, the Coloradoans case itself is a historical document, as is the Dred Scott case, so yes, and that's in that sense, yes. But this was not a course in legal history. It was a course in constitutional laws, and it wasn't a course in historical scholarship generally, or even in legal historical scholarship. It was a course largely, mainly dedicated to explicating the meaning of the 14th Amendment.
Okay. Did you introduce some elements of historical legal scholarship to your students, and I'll ask you the next question after that.
Not that I recall.
Okay. In preparing your courses, did you engage in historical scholarship, looking at some of the history of documents surrounding the formation and ratification of the 14th Amendment?
Well, I think only to the extent that I've already explained.
Okay.
I did not, that I recall, drill into the ratification or framing of the 14th Amendment. No.
Okay. All right.
This was a first-year law student course.
I'm sorry, was I?
This was a course for first-year law students, and did not go into. I mean, I discussed the Civil Rights Act of 1866.
So law students learn con law in the first year, and it's unusual. Usually they'll start the articles
Okay.
or the well-known amendments.
Your Honor, I
like the
would
First Amendment,
renew my
15th
proffer.
Amendment,
Does
15th
that
Amendment.
answer your questions?
Your Honor, we would continue to object. Teaching a first-year law school course does not mean that you make contributions to the scholarly literature on the history of the 14th Amendment at Section 3 in particular.
Your Honor, if I may, we're going to go through his resume at length this morning, so this may be a while.
Yeah.
This may be a long morning, but we'll do it. Professor Delahunty, I saw that.
Oh no! Oh, sorry about that. Oh, I'm having a little problem here. Fix it, Joe. Fix it, Joe.
Electors, as understood at that period in 1787, were considered to be people who had essentially unfettered freedom to decide whom to vote for as a leading figure in the state. So, for example, I found that the King of England was an elector for the Emperor of the Holy Roman Empire, and the framers, as subjects of the King of England before the American Revolution, were probably aware of the king's role as an elector. He was not just the King of England, he was the King of Hanover in Germany, and as such, he counted as an elector for the empire. My conclusion broadly was that presidential electors in this country had the freedom to vote for a candidate whom they were not pledged to support. In other words, that they were not bound by state restrictions on their ability as presidential electors to select a candidate who who in their judgment was best suited to be the president. That view, which was really based on original materials, was rejected
It does look a little
by
like
the U.S. Supreme Court in the Chiafalo case, which upheld the binding quality of the pledges electors made to vote in a certain way, but it was an attempt to clarify, using contemporary dictionaries and so forth, the meaning of
Witnesses listed in the
what an
banner.
elector was in the electoral
Described in the
colleges.
banner below.
Okay. I saw that you also wrote an article on who counts the 12th Amendment and the vice president and the electoral count. I think
Mhm.
we'd spoken a little bit about that.
Mhm.
Can you tell me what that was about and use, if any, of historical documents and scholarship?
Well, there was extensive use of historical materials, both from the framing period in 1787 and much later. And it wasn't just documents, it was historical practice, such as the role the vice president had played in the electoral vote count of when John Adams was in the chair and was George Washington's vice president. And then when Thomas Jefferson, as vice president, also oversaw the electoral vote count. They both assumed they had authority to admit or reject
Okay.
contended votes.
Okay. You also wrote an article, it looks back in 2006, entitled Executive Power versus International Law.
Mhm.
Can you tell me a little bit about that?
Honestly, I don't remember that one. It was, as is the tradition, I think, at OLC, I was certainly steeped in that culture, a defense of presidential power, executive power in wartime.
That is clear.
It's been a long while since I looked at that or thought about that. I think, however, it made a reference to the prize cases, which is one of the cases that is helpful in construing Section 3 of the 14th Amendment.
Okay. Let me ask you this. In your work, have you, well, let me, before I go there, you said you spent time in the Office of Legal Counsel, correct?
Yes.
What were your duties or activities there?
Essentially preparing legal opinions primarily on constitutional law and reviewing bills before Congress to determine whether, in the view of the executive branch, the bills included unconstitutional provisions.
Okay. Did you have an opportunity to work with historical documents in those instances?
Yes.
Describe what that, an example or what that process might look like.
Well, I remember one frantic weekend when I had to write an opinion on the constitutional validity of President Clinton's appointment of a member of Congress to be our first ambassador to Vietnam since the war in Vietnam had ended. And that involved looking at historical practice and opinions going back, as I recollect, at least as far as James Madison.
Okay.
But it was, how shall I say, the meat and potatoes of OLC and my work, therefore, to opine on constitutional questions across the board.
Okay. In your work, have you spent time looking at and analyzing records of congressional proceedings?
Yes,
Okay. So are you familiar with the congressional reporters
yes,
as they were developed then?
yes.
Okay. In your work, have you spent time, and if you can describe this, working with historical legal opinions?
Oh, yes,
Have you spent time working with sort of the congressional debate issues and historical legal cases from the
Down in the
19th
banner.
century?
yes,
Can you speak up?
yes, yes.
Okay. Have you spent time over your years of experience working with contemporaneous reports on congressional and public debates involving constitutional issues?
Yes,
Okay. I think you testified, but I want to confirm, have you spent time analyzing and researching and reviewing historical definitions of words and phrases?
oh, yes, yes,
Have you spent time looking at sort of historical executive orders and statements as an aid to interpretation of laws?
yes,
Okay. Now you reviewed, correct, the congressional debates or records of congressional debates, historical cases, contemporaneous debates, dictionary definitions, and executive orders in rendering your opinion on the Section 3 of the 14th Amendment. Is that correct?
I'm sorry, could you repeat that?
That was a very long question.
Yes,
In preparing and rendering your opinion today, did
almost
you
like we're looking into
rely
his brain.
on records of congressional debates?
yes,
Okay. And do the records of congressional debates for for Amendment 14, Section 3, do they differ in an approach or quality or in any way that you may be able to describe from congressional records used to interpret other constitutional provisions?
no, none that I can see. Maybe there are fewer, less discussion of Section 3 than some other provisions, but no, in quality and maybe in quality there's less, but in quality they're the same, I think.
They were written in the English language as used in the
There's
19th century.
Yes, there's,
You need to wait for Mr. Gessler to finish his question before
Fine.
you start answering,
sorry.
because
Go
the
on.
court reporter can't.
I'm sorry.
Yes, in court, we have to be exceptionally polite and never talk over one another, or to the best of our
I
ability.
apologize.
So in your experience, were they sort of written in the same English language syntax as other forms of 19th century documents?
Yes,
Objection leading.
I was leading.
I'm overruled. He's just laying a foundation.
Thank you. And you've discussed your, I'll even try to be a little bit more open-ended, Your Honor. You've discussed your research of legal cases, historical legal cases. How do those compare with the legal cases that you reviewed and analyzed in preparation of your opinion here today on the 14th Amendment?
no way.
I'm sorry, you say no way. How do they differ, if at all?
Again, I'm going to have to ask for the question to be repeated because I've lost it.
So you reviewed you have in your work over this last 4 decades, interpreted historical cases from the 19th century. Is that
Yes.
correct?
Yes,
Do the historical cases that you reviewed for the 14th Amendment, in your opinion, do they differ, or how do they differ as far as their any characteristics, as their writing, their modes of analysis, do they differ, and if so, how, from the types of cases that you've analyzed in the past from the 19th century?
no, not that I can think of, no.
When you say no, does that mean you are not able to identify any types of differences?
None that occur to me.
Okay. In looking at reports involving sort of public reports or what we would today call media reports, newspaper reports of congressional and public debates from the 19th century.
Mhm.
Did those differ in any manner, and if so, describe it, from the types of documents involving public and congressional debates that you reviewed for your opinion?
Well, I don't immediately recall reading newspaper articles from the 19th century, but if they were reports of cases, no, they would be equivalent, I think, to a case reporter now.
Okay. And have you had experience reviewing sort of dictionary definitions from the period of the 1860s and 1870s in your work?
Well, the case I can recall where I did that was research on the background of the for our potential filing of an amicus brief in Shari Kafilla versus Cobb.
Okay. So
I mean, I also looked at 18th century dictionaries of the English language, like Dr. Samuel Johnson's. I think I did that in preparation for the research I did for the piece on the Electoral College and the rights of electors to decide independently. So I think I used Samuel Johnson's Dictionary of the English Language, which is 18th century, in connection with the research for that article, which in Cardozo.
So your review of, so did you review dictionary definitions for the opinion that you rendered on the 14th Amendment, Section
Yes.
3?
Objection, Your Honor. No such dictionary definitions are disclosed anywhere in his report.
There is a reference to.
Hold on.
I'm so sorry, Your Honor. Used to this.
Response?
Your Honor, he was in general viewed as a rebuttal expert to Mr. Magliocca, and to the extent Professor Magliocca relied upon those, we've had Professor Delahunty review Magliocca's testimony, as he's allowed to do, and to render an opinion on that. We're not looking to go substantially outside of Professor Magliocca's report, and nor are we looking to go outside of Professor Delahunty's report. If there's an objection specifically to opinions, but we believe that within his report, he did mention various definitions. To the extent there's a objection about a specific, we're certainly willing to take that up. But as a general matter, the point is that Professor Delahunty has reviewed dictionary definitions contemporaneous, similar to any ones in this case.
I'm going to let him testify about the dictionary definitions that Professor Magliocca testified about.
Okay.
If he's talking about different dictionary definitions from the 19th century that haven't been disclosed, that's another story.
And that's fair, Your Honor. Okay.
So
Yeah, I have-
objection overruled.
I may answer the question.
Okay, that's not normal, but
Oh.
what's your question?
Well, I think a lot hinges on what we mean exactly by a dictionary.
Oh.
I do.
Address
So,
this.
Professor Delahunty, why don't I ask you a few of those questions, and
Okay.
feel free to ask me. We'll clear it up. So in rendering your opinion, you, I think both you and Professor Magliocca discussed a executive order or executive statement, I should say, from President Grant.
Yes.
And I want to be a little more concrete here. In reviewing that executive statement, did that differ from the types of executive orders or executive statements that you've reviewed in the past and worked with from that period of history?
No.
Your Honor, I would renew my proffer.
We would renew our objection.
Okay, I'm not sure he He's already been endorsed as an expert on constitutional law and the application of historical documents to 19th century statute and constitutional provisions. So I'm not sure he needs to be designated as an expert on Section 3 because I'm going to let him testify about what he did regarding Section 3. I don't think that, unlike Professor Magliacca, who has clearly, spent years studying it and is an expert on Section 3. I don't think he is, but I don't think it matters because what he's done is he's looked at historical documents, which he is an expert in, and is going to hopefully testify as to what his findings were using that expertise regarding Section 3.
Your Honor, we endorse that perspective.
What we're watching is a fight here as to about what areas he's qualified as an expert.
if I can
Because
ask
those are the only
have it admitted
areas
to
he can
evidence, but we
testify
endorse it, Your
his
Honor.
opinion to.
Okay,
And
let's talk about the substance of your
and they want him to
of
refute
your opinion.
Magliacca, who
Professor.
testified for the petitioners earlier.
And did you listen to or review Professor Magliacca's expert testimony on Wednesday?
That was the weird
I did.
looking
The live
Nosferatu
stream
guy.
testimony, yes, I have both watched it and read the preliminary transcript of it.
Okay.
In fact, if I might add, I read his reports there too. I've read them very closely and several times.
Okay, and so you prepared to respond to or comment
I
on his
am.
analysis?
Yes.
Okay. Let's start as a general matter. He testified that Section 3 of the 14th Amendment is not limited to the events of the Civil War. What do you think of that statement?
I do agree with that. I think there are scholars who might dispute that. But after, and frankly, it was when this issue of Section 3 began to come up, my view was, well, how can that possibly be? It's clearly confined to the Civil War, but as I delved more closely into the matter, I think the better view is that it's not time-bound in that way. It's not restricted to the events of the Civil War or to the people involved in the Civil War. And I think there are three reasons in support of that. One is that the text itself of Section 3 does not, in express terms, limit its application to the Civil War. Second, there is some highly relevant congressional testimony by the framers of Section 3 that it was
Trump
meant
is going to
to
be on the ballot.
extend into the future. And third, the
What we're watching
practice,
is how the
although
story unfolds to
limited,
get there.
has been to extend it, apply it to events involving people who had no role whatever in the Civil War.
Okay.
And Mr. Gessler, could we just take a slight pause? I want to talk to the court reporter for a second.
Okay. Do you want us to take a 5-minute break, Your Honor, or?
No, well,
Just-
let's find out.
Okay.
So, yeah, some of you in my audience are very, very intelligent. Some of you are very, very confused. Some of you are AOMs. So, my opinion of this judge is that she should have recused herself. That's my opinion. This should not be in state court. This should be in federal court. And if it was going to be in state court, it shouldn't be in front of a judge who donated to an organization that wanted to censure the Colorado GOP, was founded for the purpose of censuring the Colorado GOP for allowing Trump on the ballot. Jessica B. Good to see you, Jessica. YouTube member.
I just tried to get reconnected to the real time so that I kind of helps me to make sure that I'm following what the professor's saying.
So
should I speak louder?
they're trying to get him in as like a 14th Amendment expert based on his 15 years teaching constitutional law. And he says,
I'm
I
not
don't
sure
just
if it's
teach con law, because
if
con
it's
law is a lot
a
First
volume
Amendment.
or
Fifth
if
Amendment.
it's just your mannerism of speaking, but I'm having a little bit trouble following you.
Okay.
And I've also lost the transcript, so I was hoping to get the transcript back, but if not, we'll just proceed.
All right. So she had trouble hearing also.
Nobody's connected. Why don't, we'll just deal with it on a break then. Sorry for the interruption.
No problem, Your Honor. Are we prepared to go forward?
Yes, please.
To
Professor
me, it seems
Delahunty,
like-
I want to talk a little bit. We're just going to dive into some of the main subjects here. I want to talk about the definition of insurrection.
Mhm.
And Professor Maglioka provided a very specific definition of insurrection and looked at historical documents like insurrection examples of events.
I don't
and
think they're that
judicial
close to our
decisions
vest.
and the treatment of the law during the Civil War. What's your review of those documents tell you about the definition of insurrection?
I agree with you, Stefani.
Some of the materials that he offered
Stephanie?
offer
Stefani.
quite
He spelled like
broad definitions of insurrection. So others narrow ones, so they differ. In particular, he cites the definition of insurrection that is was drafted by Professor Francis Lieber, who was one of President Abraham Lincoln's chief legal advisors during the Civil War. And Lieber's definition of insurrection appears in Lincoln's General Order number 100 to the Union Army. And Professor Maglioka says that Lieber was, I don't have his transcript before me, but in effect, the leading legal scholar of his period. And Lieber actually taught at Columbia, which I'm proud of. And in General Orders number 1, which I have studied and taught about for quite a while, Lieber says, again, I don't have the text right in front of me, but he says, in effect, an insurrection is a rising of the people in arms. So if you accept Lieber's definition as definitive or at least very weighty evidence of the meaning of insurrection, an insurrection would have to be in arms. The insurrection.
So once you're relying on this guy, they have to be armed.
And that's, I think, inconsistent with many, if not all, but anyway, many of the other definitions, including the case law that Professor Maglioka cites. But so there's some contradiction, is perhaps too strong a word, in tension between the accounts of insurrection that some of its sources supply, which don't require that the insurrectionists be armed, and Lieber's definition.
Okay. Professor Maglioka
I don't
also
think there's any
cited
charge that she's been
Webster
bribed.
Dictionary definition
That's
of
what you're implying.
insurrection in 1828. Do you remember that?
I remember that he cites it, yes, and I read the quotation, yes.
Okay. And I'll quote you that it said, rising against a civil or political authority, the open or active opposition of a number of persons to the execution of a law in a city or state. And then he also cited to a John Bogue dictionary definition of insurrection as being identical to the Webster definition. What do you make of that interpretation? What's your interpretation?
Well, the Webster definition specifically refers, as you quoted, to states and counties. Obviously,
5 people
it's
had weapons
highly
charges.
relevant, competent
why they took 'em
evidence
out on
about the meaning of insurrection in Section 3, but it's by no means identical, because insurrection as used in Section 3 must be
Does look like the guy from
against the
Jurassic.
Constitution of the United States. And the United States isn't a state or county. Is not, oh, I'm sorry, Your Honor, is not a state or county.
And what's the, when you say insurrection against the Constitution of the United States, what's the importance of that distinction?
I think that is really crucial because while it is certainly very helpful to know what insurrection was understood to mean or likely understood to mean in from 1866 to 1868, while that's certainly very useful, Professor Magliocca himself emphasizes that there is this important limiting principle which is found in the text of Section 3. It's not just any sort of plain vanilla insurrection. It's an insurrection against the Constitution of the United States. And that's in the text. And it is a critical element of the offense at issue that the insurrection be an insurrection against the Constitution of the United States. In other words, insurrection is not a freestanding term in Section 3. It's coupled with, by Professor Magliocca's own insistence, really, it's coupled with that other phrase, insurrection against the Constitution. So what really needs to be explicated and decided is not the sort of plain vanilla, as I called it, meaning of insurrection, but the whole phrase, insurrection against the Constitution of the United States. And there's no, to my knowledge, any dictionary definition or definition in a legal dictionary of that phrase.
Okay. Professor Magliocca also testified that before 1862, there's no
I don't know
federal
if that's
crime of
helpful, really.
insurrection, and that the cases that discussed insurrection were really treason cases. And so, for example, he cited a grand jury charge from the U.S. Circuit Court in Missouri from 1861, which specifically said the conspiracy and the insurrection connected with it must be to affect something of a public nature concerning the U.S., and that included, quote, overthrowing the government or to nullify and totally hinder the execution of some U.S. law or the U.S. Constitution or some part thereof, or to compel its abrogation, repeal, modification, or change by resort to violence. What's your view on the use of that grand jury charge and the importance of that, or lack of importance,
Your
with
Honor,
respect to defining insurrection?
I'm going to object again. They've had Professor Magliocca's report in this case for about a month before they submitted the rebuttal report in this case. And the rebuttal report in this case did not discuss any of these sources.
I'm gonna overrule the objection. I am though gonna ask Mr. Gessler, when you read from
Be
the,
slower.
be slower for the court reporter.
I just got that right. I'm sorry, Your Honor. I'll calm down and work at being slower. My apologies.
You're both offending you both are now hard to understand and hard to report for the court reporter.
I think it's just the slowness of the internet connection, Your Honor. No, I'm sorry. I'll work on that.
So I think you probably need to repeat the question.
So Professor Delahunty, I gave you a very long quote from a
Yes.
grand jury charge
Yes.
from Missouri.
Yes.
Do you need me to repeat that, or are you able
If
to?
you could give it to me in more abbreviated form. I'm familiar with the Justice Catherine's discussion of the meaning of insurrection, quoted by Professor Magliocca.
So it says the conspiracy and the insurrection connected with it must be to affect something of a public nature.
Yeah.
And it included overthrowing the government to nullify and totally hinder the execution of a law, constitution, some part of it, or to compel its abrogation, repeal, modification, or change by a resort to violence. What do you think of that use of that sort of historical document?
I think it's relevant to discussing the meaning of insurrection as understood, as that term was understood in the immediate run-up to the Civil War. It is helpful in that connection, especially because it comes not from a state court or lower federal court, but from a justice of the U.S. Supreme Court.
I'm going to save this and
And
answer it
how
by the
does
break.
that definition
We have a
compare
break.
with other definitions that Professor Maglioka testified to?
Well, I can't remember in detail the other definitions, their framing, their phrasing. He says that it's relevant to understanding Section 3. It is. Is it consistent with other definitions from roughly the middle of the late 19th century? I think it's certainly not in contradiction with them, except Lieber. No, it's not even in contradiction with Lieber, because I think at the very end, he talks about violence.
So is it a more sweeping definition than some of the other definitions that you reviewed?
Probably. I mean, and something of a public nature is pretty broad.
Okay. Professor Maglioka also discussed the Whiskey and Freeze rebellions as insurrections. How do they relate, in your view, to the interpretation of the meaning insurrection against the Constitution?
Well, Professor Maglioka says that they are not the kind of insurrection that is covered by Section 3. And whether that's true or not depends on how you interpret against the Constitution in Section 3. He offers his own interpretation. It's not a dictionary definition. It's his interpretation of what insurrection against the Constitution means. And he says under his interpretation of that constitutional clause, the Whiskey and Freeze rebellions are not insurrections against the Constitution of the United States. I think that depends on the meaning of insurrection against the United States. And there could be a broad or a narrow reading of that constitutional language under which both insurrections were against the Constitution of the United States.
And what would that reading be?
So Professor Maglioka offers this interpretation that an insurrection against the Constitution of the United States is an insurrection that interferes with the execution of the Constitution. And then the question becomes, well, what is the execution of the Constitution? And in substance, as I understand him, he's saying the execution of the Constitution is interference with the federal government's political branches and judicial branches' performance of their constitutionally appointed functions, if it interferes with the discharge of their constitutional responsibilities. And he argues that certainly the events of January the 6th are an interference with the congressional duties assigned by the 12th Amendment to
And that's why I wonder,
minimally to
now
observe.
walk us through, why is it
vote
adding
count.
that term of against the Constitution?
Now, on that definition of interfering with the execution of the Constitution, it seems to me that
Here's the language of
there
the
could be
14th Amendment.
many other events that were similarly insurrections against the Constitution, even in the sense of executing the Constitution. For example, if there is a interference with the execution of the judicial function of adjudicating cases, clearly a responsibility of the federal judiciary under Article 3, if you interfere with their execution of their constitutionally appointed judicial responsibilities, that would also, by burning down a courthouse or disrupting judicial proceedings, that would also, I guess, under that understanding of against the Constitution, be an insurrection against the Constitution or against the execution of the Constitution. Or to take another case, the Constitution assigns to the Senate the role of debating and deciding on presidential nominations to principal offices of the United States. So let's take appointments to the federal judiciary. If you have a crowd disrupting the Senate's vote on a presidential nomination, that would seem to be an interference with the execution of the Constitution. In fact, you could, I think myself, under that definition of interfering with the execution of the Constitution, that even disrupting the delivery of the mail, which was the issue in the Supreme Court's decision in the Debs case,
According to
would count
Magliocco's,
as,
disrupting the mail.
interference with the execution of the Constitution, because the president has the constitutional duty
Would be insurrection.
to ensure that federal law is faithfully executed. So you're interfering with the president's execution of his
It's much closer.
constitutional duty to execute the postal law.
And why do you say the Postal Service?
Well, because Article 1 mentions the Postal Service, and it's apparently, as Debs understands it, a duty of Congress to execute that power and to create and instruct the president how to administer the statute regarding the post office. So to cut it to the chase, basically, I think that under even Professor Magliocco's interpretation of against the Constitution, disrupting the delivery of the mail is an interference with the execution of the Constitution. And you could go on with examples of interference with the execution of their responsibilities by the president, by the Senate, by the House, by the courts, that would count as against the Constitution as he understands that. So what is meant to be a limiting principle is, I think, a very expansive one, unless you attach
Great. That's a great point.
a more limited scope to the meaning of against the Constitution. And on what I think is his understanding, it does cover, although he denies this, the whiskey insurrection and the Freeze insurrection.
And so that definition also includes intimidation, correct? Or are there sources that talk about mere intimidation as the necessary threat of violence for insurrection?
I'm sorry, I don't really understand the question.
Okay, let me move to a slightly different area.
It's an interesting philosophical question, Sandy. Sandy thinks deeply.
So I'm going to just ask you a question. So as I understand it, what you're saying is that if you take Professor Magliocco's interpretation of what insurrection is simply that it could just apply to a litany of different things.
Yes, really, almost all, if not all, interferences with the execution of the duties of the president, the Senate, the House,
Or
and the
any
federal
executive
judiciary.
branch. If you stand in the way of,
It is a limit.
if you stand up to the
I assume you
FBI,
get to what
that's
he thinks
insurrection.
the definite, what he thinks it should be.
To the extent that's possible, yes, Your Honor, from the texts. Let me ask you this. Professor Magliocco also testified that
pulling a
the
fire alarm
shall
in
have
Congress
engaged in
is insurrection.
insurrection or rebellion language means
Great
any
example. I wish they
voluntary
would ask
act in
that.
furtherance of an insurrection against the Constitution, including words of incitement. And he based this on judicial decisions and a U.S. Attorney General opinion of Attorney General Stansbury. What's your opinion on that? On the use of Stansbury's opinion in defining what insurrection is?
I would have three thoughts, I guess, about that part of Professor Magliocca's testimony and report. First of all, I would say it's a linguistic point. I think engage in insurrection has a more restricted meaning than he supposes. Let me give you, this is sort of, speakers of the English language, I think, would think this. If we use a phrase like engage in
I agree. It is
hostilities,
pure insanity.
we probably have in mind combat, not the preparatory actions that would go with engaging in hostilities. I think intuitively we would distinguish engaging in hostilities from engaging in incitement, let's say, to hostilities. So that's just a linguistic point. But the backdrop to the Constitution's Section 3's use of engaging in insurrection, part of it is the Second Confiscation Act, which I think Professor Magliocca cites, which itself distinguishes between various preparatory or accompaniments of engaging in insurrection or rebellion and engaging itself. That's the language of the Second Confiscation Act. And so the act distinguishes between, let's say, inciting an insurrection or rebellion versus engaging in it. The Congress had that template before it and cut out, or at least didn't include, all this other language. And in Section 3, it narrows it to engaging in insurrection or rebellion, which I think very strongly suggests that it was not covering the same class of activities as the Second Confiscation Act did. So engaging in insurrection in Section 3 has a narrower meaning than the comprehensive sweeping account of the activities associated with insurrection or rebellion that you see listed, enumerated in the Second Confiscation Act. I agree with Professor Magliocca that Attorney General Stansbury's two interpretations of statutes, in the Military Reconstruction Act of 1867, I agree with him that the Attorney General's opinions are certainly good evidence as to the meaning of engaging in insurrection in Section 3. They were opinions that were written while Section 3 was being debated and in the process of ratification. Stansbury actually has a section in the first of his opinions dealing with the statutory language of what it means to engage in insurrection. So that's contemporaneous. It's from a high officer of the executive branch. It is about a statute, but it sheds light
Insurrection Act.
on what engaging in insurrection means for Section 3 purposes.
And looking at the Stansbury opinions, what's your view on how he defined insurrection and its application to Amendment 14, Section 3?
So
Oh,
I think Professor Maglioka describes what Attorney General Stanbury is writing about.
look at this.
When
very important.
in the first of these two opinions on the Military Reconstruction Act, in the first of them, Stanbury has a section.
This is
called
pretty
something
important.
like engaging in insurrection
Let me share
and
this with you.
rebellion. Well, I think it's actually
This is what he's
called
talking about here.
engaging. Well, anyway, it's about engaging in rebellion or
It says
insurrection.
here,
So
further
Stanbury
enacted that person shall
says,
hereinafter
okay, this is what he's
incite,
going to
effort,
explicate.
assist,
This
or
language
engage
in
in
the
any rebellion or
statute.
insurrection.
And he
So
starts
engage
by
here in this
saying
context,
that
in this act, is used differently from incite.
engaging in
Incite
there,
does not mean engage, otherwise they wouldn't say incite. They specifically say incite
you have
in
to
the Second
distinguish
Confiscation Act.
between active and passive engagement, the participation in rebellion.
That's what he's talking about now.
Stanbury is here primarily addressing what it means to engage in rebellion, not insurrection. So you have to start, Stanbury says, by distinguishing
When this
between
says,
active and passive participation. And passive participation in rebellion doesn't count under the statute. So that's his first sort of distinction. Then he says,
as opposed to,
there's a distinction to be
14th
drawn
Amendment,
between
which says
voluntary
only if
and
they have
compulsory
shall
or
have
involuntary
engaged. It leaves out incite.
participation in the rebellion. So
Bam.
not only does the participation have to be active, but it has to be voluntary. If you are coerced to assist the rebellion, that doesn't bring you within the meaning of the statute. So one distinction, active passive to voluntary or
Yeah,
compelled.
there's been zero testimony
And then he has a
that he's
third
guilty of providing aid
distinction
or comfort. So you can
between
speculate that, but
participation in an
none of the
official
petitioner's lawyers think that
capacity
that's a pretty sound argument.
and participation in the
Hang your
purely
hat on that.
individual capacity. And he has a pretty extensive discussion, Stanbury does, of what official, voluntary, active participation in a rebellion would be. That would include things like being the so-called Confederate States ambassador to France, okay?
Yes, I can.
That clearly is not being a combatant, right? But then there's also a discussion of what it means to participate in rebellion in an individual capacity.
Give me a moment to do that.
And so the statute has to be understood in one way
This
if the
says-
charge of
this is the 14th Amendment,
engaging
which is where they
in
want to remove
insurrection.
disqualified.
is going to be charged against someone acting in an official
saying
capacity and then
You can't get
against someone who is
you can't
charged with
become
acting in
president
a
because you're an officer.
individual
If you
capacity.
took an
So,
oath, you previously took an oath
To
when
bring
you were
you under
serving.
the statute, you,
in
if
certain
you were acting in an
constitutions.
individual capacity,
And
would
then
seem to
you
require
shut
different
and you
tests
engaged in insurrection.
from
That's that's the language.
acting in an
Engage in
official
insurrection.
capacity. And okay, let's talk about President Trump.
Now,
One thing,
this
if you just
Confiscation Act
map
was passed
on
a few years earlier
the
during
interpretation
the Civil
Stanbury
War. That was
offers
at this,
of,
right after the Civil War. This is during the Civil War. They say
I'm going to object.
you can
to
have
any
your property
opinion
confiscated
as to what President Trump
if you
did or did not
incite,
do as
set
both
foot, assist,
undisclosed
or
and outside
engage.
the scope of his
So they're adding
expertise.
in not just engage, but even if you just incited
Oh,
rather
I
and you
don't know what he
didn't
was gonna
engage,
say,
you still
but
can have your
I'm gonna
property
sustain
confiscated.
that objection.
So it's showing
okay.
that engaging.
Let me ask you about
different from
Stansbury's
incitement.
definitions as
And
well. You
now
said he
the
was.
petitioner
If
is
you go
saying
back, I just asked the
incitement is
first
part of
question, so
it.
you kept referring to the statute,
It's the Military Reconstruction Act.
okay, and that's what Stansbury was defining.
Yes, yes. Or sometimes called the Reconstruction Act. I think that's probably the more common.
And you said Stansbury was talking or opining about rebellion primarily.
Primarily, yes.
Can you talk a little bit more about the differences?
means you might have
both in his
engaged and
analysis,
not incited. You
rebellion
might have
versus
incited
insurrection,
and not
how that
engaged.
applies
Either
to
one of them
Section 3 of the
would
14th
make you
Amendment.
subject to the
Well,
Confiscation
most
Act.
of Stanbury's
But it means those are two different
discussion
terms
in the
in their
first
minds.
opinion, at least,
That's what it means.
is about the meaning of engaging in rebellion.
Whereas the 14th Amendment that says you
and why
can't
does
hold
that matter?
office, that only applies if you specifically engaged.
Well, it's not directly on point as to what engaging in insurrection means under the statute. It certainly sheds light. I'm not disputing that. I'm just saying it's not directly about engaging in insurrection under the statute. So it's certainly helpful.
The Confiscation Act is not what's
But
keeping him out.
to cut to
This is
the
where you're so
chase,
confused.
I'm not sure that everything that Stanbury
Confiscation Act
says in
applied
connection
to
with engaging
specifically
in
the Civil
rebellion
War.
carries
It was passed
over
in
automatically
1862.
to engaging in insurrection, the statute which carries
During the
over
Civil War,
automatically
if
into
you
the meaning of
merely
engaging in
incitement,
insurrection, section 3,
You were subject
These
to the
are all
Confiscation Clause and you could
steps.
lose your property.
in a process.
After the Civil
and then,
War, they say we're going to punish the people who
If
engage.
someone's charged with engaging in
We're not
insurrection,
punishing the
it would
people
have
who
to be
incited.
determined whether
The
that
point of the
engagement
Confiscation
was
Act is that
in
it
an
shows
official capacity or an individual
and the
capacity.
minds
So
of
as
these
applied to
folks,
someone, you
incitement
have to
and
ask whether
engagement
that
are two
engagement
different
on
things.
his or her part was
So you cannot come in 2023 and say,
in
well,
an
it says
official
engage. It
capacity
also means
or
incite.
individual
Because
capacity,
clearly
which
to the
could
folks
be
who wrote
quite
it, it did
problematic
not
to
mean
decide
incite.
legally.
So stop
And-
with your
and
or,
why is that?
stop with your
What's-
idiocy.
I mean, how
Wake up
would
and recognize what
Stansbury's
they were
opinion, to the
saying.
extent
They
it's
think
possible to
incitement was the
determine,
same thing,
apply
was part
to,
of engagement. The engagement was so broad it includes
activity
even
in a
just inciting like Trump
individual
did.
versus official capacity?
Well, this is all sort of uncharted territory, but not everything that Professor Maglioka says about Stanbury's opinion when he quotes from it quite at length. Not everything he says immediately translates into every single case. You'd have to decide whether the language he quotes about engaging in rebellion in an official capacity also carries over to whether that is true of someone who engages in insurrection in an individual capacity. So you, before applying his account, Stanbury's account, you'd have to decide, is this person acting in an individual capacity or not? Is he or she acting individually? And does that matter? Does everything Stanbury says about engaging in rebellion in an official capacity immediately carry over into such engagement in an individual capacity? So construing Stanbury is quite difficult in itself, let alone reading whatever he says into about the statute into Section 3.
So, did Stansbury provide standards or guidance as to exactly what constitutes or what type of liability attaches for actions in an individual capacity with respect to rebellion?
No, I don't think he talks about, at least not in the part headed engagement in. I don't think he talks about the liability to which one is exposed. No, because he offers examples, I think, more than standards about how to apply the statutory term. But he doesn't discuss the liability to which you're not in that part. Doesn't discuss the liability to which someone who is found to have engaged in insurrection is exposed.
Does he discuss exactly how to determine whether a person has engaged in rebellion when they're acting in their individual capacity?
He does discuss that. And I don't recall exactly the language, but if we just focused on that part of Stanbury's opinion, you'd have to make the threshold decision whether individual capacity or official capacity applies here. But he does offer some language about how you have engaged in rebellion in individual capacity. Yes, what that language is, I don't have directly in hand, but
Okay. Now, he also, Professor Magliocca also compared the Stanbury opinions to the Worthy cases from the Worthy case from North Carolina. And he said that they were the definition for engaging in an insurrection was the same in the Stanbury opinions and the Worthy case from North Carolina. What's your opinion on that?
well, Stanbury is talking about a statutory term, and the North Carolina opinion, the Worthy case, is talking about Section 3.
And tell me about the Worthy case. When you say it talks about Section 3, that was a North Carolina state case,
Right.
correct?
Yes, and it's decided under a state statute that
I don't know how incompetent some
incorporates,
people are.
Section
It
3
says
by
right
reference.
below
It
your
applies
message
it.
there, there's a
The
blue
North
banner
Carolina
scrolling
had
across
operationalized
that says Robert Delahunty, qualified by
the
court as
enforcement
expert in
of
use of historical
Section
documents to
3,
interpret statutes and
at least as
constitutions.
to state officials,
Right.
state officers, not
You do you,
to
brother.
federal officers, federal
I tried walking
federal
you through
officers
basic
or
language.
officers.
You can't even find. I'm trying. This is who I'm talking to. Someone
It's
who
relevant
thinks I removed the
to
banner.
understand. I don't think it's relevant to understanding what engaging in rebellion or insurrection means in the Constitution in Section 3.
And why is
It's
that?
more-
Why don't
it's-
you think
it's really more relevant? Well, it's not identical with what Stanbury offers.
That's what's coming
but
apparent.
It's more relevant to the question of whether Section 3 is self-executing than it is, I think, to, if it says the same thing as Stanbury, then it doesn't carry the ball further.
Okay. We'll get to the holding in just a minute, but is it your opinion that the definitions with respect to engaging in rebellion differ between the Stanbury opinion and the Worthy case?
Not that I can think of, no.
Okay. Okay.
Excuse me, may I just get a little more water?
Go ahead.
So the point to the Confiscation Act, those of you who joined late, is that it was a statute that was written during the Civil War, which was basically saying if you incited or engaged in
So
an
you had
insurrection,
talked a little bit about insurrection against the Constitution.
you will have
as
property
used in
confiscated.
Section 3, correct?
Yes.
Okay.
But the
What if
Amendment
any?
just says engaged. And then it throws on the end, or
Well,
if
let me
you
ask
get
you this.
aid and comfort. But the
To
aid and
what
comfort
extent
that
do the
some people in the chat are
historical
talking
sources
about.
allow us to create a specific definition of insurrection against the Constitution?
The petitioner's in that tried
Well,
claiming
I'm
he
not
gave aid or
aware
comfort. Nobody's tried
Of
claiming that.
any discussion in
Is that normally
Congress or
means
the
you bring him into your
ratification
house. That's what aid
debates
and comfort means.
about
Not that you say nice words.
that limiting principle against the meaning of the Constitution. I don't know of any.
Not that you say, wow, you're great, I love
And-
you. That's not giving
And
aid
so
and comfort.
you've looked at Professor Magliocca's sort of approach to limiting the
Nobody
Constitution.
with a brain has made that claim.
Are you able to create a definition of insurrection against the Constitution based on the historical documents?
Well, I would say this. I would look to guidance more to the remarks that Senator Jacob Howard makes in introducing the 14th Amendment to the Senate, which are those remarks of Senator Howard are cited, I think, twice in Magliocca's report. And I don't have Senator Howard's exact language, though it appears both in Magliocca's report and mine. But Howard says something to the effect that this section of the Constitution is meant to cover actions, to sanction actions that acts that are that pose. I just don't have the exact language, but essentially a grave to the threaten to. I don't. It would help me if I could have.
Let's bookmark that. We're going to
Okay.
pull up the language for you.
Essentially,
in a second.
that would destroy was the term Howard used. It would destroy the Constitution. So, given Howard's role in the enactment, the ratification, rather, of the 14th Amendment, it would seem to me, I would start by looking at Howard's remarks in explicating the phrase rebellion or insurrection against the Constitution. And they would be acts that that destroyed the Constitution.
Your Honor, I'm going to object and move to strike the last answer on the grounds that his report never purported to offer any definition of insurrection or rebellion against the Constitution. This is all completely new testimony.
Your Honor, I don't think he said that I'm sorry, I keep saying article, Amendment 14, Section 3 has to be defined that way. He said the starting point is to look at Senator Howard's viewpoint as an analogy or a basis. I don't think he said that has to be the definition.
Well, did he disclose his?
That was weird. Sorry. Don't know what happened there.
The senator's remarks.
No, Your Honor.
You could give me just a few minutes, Your Honor. Let me look through his report and give you a point.
Can we come back to it?
Sure, Your Honor.
I think we'll probably break in the next 20 minutes and. we
20
can
minutes?
Revisit that.
Okay. Okay.
Well, asked, is he making this up? Because it sounds like I don't think he's making it up. I think what he's saying makes sense. It's logical.
Professor Delahunty,
The tone says Dershowitz thinks
without-
Section 3
we
only
won't
applies to
discuss,
the war. Maybe he would have been a better
Senator
witness
Howard's
than this
remarks
professor if he was willing to testify. I agree.
but
He probably
why
would have
you
been.
start from that as a
He probably would
foundation,
have been.
looking at the remarks of a congressional debate?
Same objection.
I don't know why he's not there.
Well, I don't think he's offering a different definition as he's why he would start looking there. It'd be helpful if we could see the remarks. I don't know if that's possible.
We're pulling them up right now, Your Honor.
Okay.
Montanan life.
We may even have them.
What can you do when you live in Montana? Their brains are scrambling for comprehension because they're used to be interpretation given by MSM and MSM only. Their brains are overloading, causing malfunctions. Here's the thing about these
Okay.
trolls. I appreciate the fact that at least they have the stomach to sit through someone presenting an alternative position, and they have the sufficient
Your Honor, we're going to need to just spend a few minutes on this if we
to
can
stand up
come back to it a little bit later.
to their
I don't wanna-
overlords who tell them, stay away,
I mean,
stay away, run
in
away.
general, it's been a little bit difficult to follow what he's talking about because he's talking about kind of things that we can't see. So to the extent that we can see the
Confiscation
remarks
clause.
that he's talking about, et cetera, definitely would be helpful to the court.
Okay.
They should
Your
show
Honor,
the
may I
confiscation
propose
clause.
a morning break? That'll give us a little bit of time.
Sure. Why don't we just break till 10:30 and
Okay.
come back to it?
All right, so they're going to break till 10:30. Let me
Things that we can't see.
let me
All right,
just
Chris.
make sure that's muted. Okay, so those of you who joined late, zoom in a little bit. I need to have better control of my camera. Those of you who joined late, what they're basically talking about here is the confiscation clause, which came out during the so far on the stand is Robert Delahunty, who the defense Trump's team has brought in as a proposed expert witness. A couple days ago, this funny looking dude named Magliocca came in there and was qualified as an expert in the 14th Amendment because he wrote some peer review article or something like that, or not peer review, some article in some law journal or something to that effect about the 14th Amendment, Section 3 of the 14th Amendment, which he wrote after Trump, after this whole January 6th thing. So I don't know, somehow he magically became an expert just because he decides to write an article a year ago or two. And I mean, he came out and he basically said that engaging in insurrection is very broadly defined. So what we saw there is an insurrection. He said, what's an insurrection? An insurrection is any time you try stepping in the way of the legislature, the judiciary, the executive branch. You try stopping that, the federal legislature, you do anything to impede that, you are engaging in insurrection. And he tried coming up with different sources to try and establish that. And he was pulling from things like, well, there's a case from Tennessee from 1850 where they used insurrection that way. It's like, says one judge in Tennessee 170 years ago who used insurrection that way. So he's like, so that's how we can understand that insurrection was used. So now when we're looking at this language of the 14th Amendment and trying to figure out what does this amendment actually mean, and struggling with getting a definition of it. Let me do this. I'm struggling with getting a definition of it. And there's so many different words in here which have been hotly debated throughout this hearing. For example, here's an example of the different things which, by the way, the petitioners have to win on every one of these issues in order for Trump for this amendment to have any possibility, even a possibility of applying to Trump. Even if it would apply to Trump, even if it applies to January 6th, and it does apply to the president, and it would apply to him, then you still would have to establish, well, does this apply to incitement? And then did he incite under the Brandenburg standard, which seems like it's difficult to understand how he could be guilty of incitement when he's not criminally charged with inciting. But so they've been fighting over throughout this hearing. They've been fighting over no person shall be senator representative. And does this mean you cannot be president? You cannot be president. They seem to leave out president. Magliocca was saying that when it says over here, hold any office, that applies to it means you can't be senator, representative, or in Congress, or an elector of a president or vice president, or hold any office. That means including office of the presidency. It's weird for them to list off in continually lower positions. First, the senator is considered more prestigious than representative in Congress. There's only 100 senators. There's several hundred. There's 435 members of the House. So being a senator is considered far more prestigious. And then lower than member of the House is an elector of a president and vice president. And then after that, they have or hold any office. And they say, well, this hold any office, that includes the office of the presidency. And Magliocca came up with some decision from Maine where actually in this thing, he said, you see, there was a whole debate. Why are we not including president in here? And during the course of that debate, so someone said, I'll point your attention to the phrase hold any office. So, and that's the end of the conversation. That's the end of the conversation on that. Does that mean it's applying to it? Does that mean that's what they all agreed to? I think that's a fair point to make. I think it's a fair point to say that it was discussed. So it's possible. It's just the language, having it in this order, if it's hold any office is includes president and vice president, you would think this would say no person shall hold any office or be a senator or representative in Congress or elector of the president and vice president. That's what you would think it would say. But civil and military under the United States or so this is the first part here is what's the penalty? What's the punishment? You can't be this. Who can't be this? Well, it's someone who did two things. First, while you took an oath as to be a member of Congress or an officer of the United States. And here's the other thing, because does this apply to a president who breaches or not? So they're saying who, having previously taken an oath as a member of Congress or an officer of the United States. So they're saying that when he was an officer of the United States, or in any state legislature that's not relevant to this, or executive judicial officer. So then maybe they want to say he's an executive or an executive officer because he's the chief executive officer. It's called the chief executive officer. To support the Constitution of the United States. To support the Constitution of the United States. So if you were someone who did that, you fall into this category. You took an oath to be an officer of the United States or to be an executive or judicial officer of any state. Sorry, that's not him because this is just an individual state. I apologize. This part's definitely not relevant. So to be an officer of the United States. And then the question is the president an officer of the United States? Or is he above that? Because depending on definitions, officer may not be he's above officers. Officers are assigned to the president. So some would argue it's not him. And Magliocco was trying to say, no, this applies to them. Oh, he's the officer. He is an officer of the United States. Which, look, it could be. I mean, being philosophically fair, it really could be, or it could be you don't refer to the judge as the officer of the court. We attorneys are all called officers of the court. A judge is not. It's called the court, not an officer of the court. So referring to the head as being an officer of that, when officer usually implies you're serving something else. And I understand the president is serving the United States. I understand that. And that's the logic behind the idea of saying that he's an officer in the United States. It's just an unusual way. It's unusual that, and the point is that while he's a president, according to the petitioners, that what did they do after taking that oath? That to support the Constitution of the United States, what did he do? That starts this part here. That he has engaged in insurrection or rebellion against the same. What does this mean against the same? Well, that's something that came up in testimony here right now, where he says, when it says rebellion against the same, instead of just engage in insurrection, but it says engage in insurrection or rebellion against the same. That's trying to say against the Constitution of the United States. That's how Delahunty is saying this deserves to be read. You've engaged in insurrection not just against the United States, but against the Constitution of the United States. Well, what's the difference between engaging in insurrection between the United States and the Constitution of the United States? And why would that make a distinction here? Constitution in the 12th Amendment described the whole process that was being invoked on January 6th. So when I first heard this, I was like, I don't understand why that might, if there's a difference, I don't see why that difference would apply here. But Delahunty explained that basically when you're saying that you're fighting, that you support, that when it says Constitution of the United States, what he's basically saying is that you're preventing you're insurrecting, fighting against the actual, I think he was trying to explain it as the actual I don't know. I was getting very confused by this part of it. I was like, I believe what he was saying is basically against the foundation of the United States, which I think that the petitioners would say, well, you were trying to stop the peaceful transfer of power. I think the petitioners would argue back to that. That's part of how the whole makeup of the United States works, and they were trying to stop that. So I don't think that's a very strong argument for Trump. This is when he focuses on this whole to support the difference between engage against the United insurrection versus engage in insurrection against the Constitution of the United States. But when they focus on the term here, insurrection, what does insurrection mean? And this is something that Magliocco and Delahunty argue about. Magliocco, the expert who came in for the petitioners, so he says, insurrection is a very broad term. Very, very broad term. Very, very broad term. If there's any sort of federal judicial function, any sort of federal executive function, any sort of federal legislative function, and you try and stop that, you're insurrecting. And you try bringing evidence to that based on this example here or that example there that happened 160 years ago. But Delahunty pointed out, by that logic, if you stop the mail, the federal mail, which is federal function, executive function, you're insurrecting. Doesn't make any sense. It's like ridiculous. It's kind of ridiculous at that point. There's no way that's what they meant. It has to be against, like, a foundational element. You're trying to overthrow the government. And and as someone in my chat, I think it was Kelly in the chat, pointed out, by this broad definition Magliocca gave, that you do anything to impede legislation or the Congress doing its thing, then when Jamal Bowman pulled that fire escape, that was insurrection. He's impeding it. Now, would I seriously contend that Jamal Bowman pulling a fire alarm is insurrection? No, I don't believe that. The point is that based on the definition that the petitioners are using here, insurrection happens every day. Anytime someone says the FBI, no, I'm not letting you on my property, I see your search warrant, I'm not letting you on my property, or wrongfully, anyone who basically drives slowly in front of an FBI agent who's trying to get somewhere, you're impeding the executive branch. I mean, it's stupid. It's such a broad definition that it's like there's thousands of insurrections happening across the country every single day. So it cannot be that broad. Which means that he's really, and I don't think Magliocca would make an argument that it's that broad, but that means that he doesn't really have a line that's definable that works for the petitioners. And he's trying to make it as broad as possible because he wants to say that this is, because he couldn't find a source which helps him give a definition that would not count thousands of times a day across the country, but would count the siege on the Capitol, because they're trying to persecute. They're not trying to find justice. They're just trying to persecute. And they're saying something, not trying to say this is what the Constitution demands. They're trying to say, how can we keep him out? So we're going to try and find a way to apply insurrection to this. But the other key thing here, which came up, is this phrase engage in insurrection. What engaged means you have to actually, one would think, is you have to come with the pitchforks, with the gun, with the knife, whatever. You have to be part of the army. This was really, let's look in context. This was passed right after the Civil Wars in 1867. The Civil War just ended a year or two earlier, and they're basically trying to sit there and when they come up with this, they say if you engage in insurrection. So now we're trying to figure out, well, what does this mean, engage? Well, Magliocca, for the petitioners, he came forward and he said, engaged doesn't just mean you physically fight, but even that means incite. If you incite others to engage, you're engaging in insurrection. And so when he incited others to engage in insurrection, that is engaging in insurrection or rebellion against the Constitution, and that's why this statute applies to him. Now, others in my chat here have stupidly tried suggesting that it says also, or given aid or comfort to the enemies thereof. Nobody from the petitioners' attorneys or anyone who actually understands anything about this has tried making that, because everyone understands that giving aid or comfort means like you're giving like actual physical comfort to them in a way that you're providing for them. You're enabling them by actually taking steps to hide them away, to provide them with food when they're on the run. That's giving aid and comfort. Giving aid and comfort doesn't mean telling them, I love you, you're great, you're wonderful, you're the best, you're absolutely the best, you're the best, you go on out there. That's not giving aid. That's not giving comfort. So no one who actually is involved in this fight is trying to say that give aid or comfort is relevant. What they are saying is that he engaged in insurrection. How did he engage? Because incite. And they say incite is part of engage. Well, the point that Delahunty was making here is you cannot say that engaged is the same thing. That when we talk about engaging, it also means incitement. You want to know how we know that when they wrote this, when they said engage, it did not mean incitement? How we can be positive that it did not mean incitement to them? It's if we look at the Second Confiscation Act. Well, what is the Second Confiscation Act? That's what I just pulled up here. This is the Second Confiscation Act, which basically says that the government is confiscating from some of its citizens some of their property. So I've been going through the act at length as to who it's about what was being confiscated in this act. There were a number of confiscation acts that came out during the Civil War, but the key thing here is that when they talk about, they use the same language of engaging in insurrection. It says here in Section 2 of the Second Confiscation Act, says that if any person shall hereinafter incite, set on foot, assist, or engage in any rebellion or insurrection. So this is basically the same folks 5 years before the 14th Amendment say, when they're talking about engaging in insurrection, they write this paragraph here, they say it's not just if you engage in rebellion or insurrection, but even if you incite. If you incite or you engage, in that case, you are in insurrection. In that case, all the punishments of this act are going to apply to you. Why is this relevant? Well, this is relevant because we see that to the people who are using this term, engage in insurrection, they clearly did not think that incite was part of it. Because if incite was part of it, they would not have bothered writing incite here. They would have just said engage and said, when we say engage, obviously that means incite. Whenever we say engage, it means incite. So from the fact that in this 1862 act, they identified two different types of activity. One person, John, might be inciting people, but Roger is engaging in insurrection. This implies that engaging in insurrection is not that incitement, that when John is merely inciting, he's not engaging. Because otherwise we would just say, well, John is engaging. When John's the manifestation, the nature of one person's engagement is that they're going to start shooting at the Union forces. The other person's type of engagement is incitement. So you wouldn't have to make them two different categories. You would just say engage, engage, engage. If Magliocca is right that engage includes incitement. So what we can derive from here is that when these folks in the 19th century talk about engaging in rebellion or insurrection, it could not possibly be in their minds that includes incite, and that this is broader. We don't want this to apply just to people engaging. We want it to apply to people who are also inciting. So since we want it to apply to those who are engaging and those who are inciting, that's why we're going to say those who incite or engage. But when they came to the 14th Amendment, when they're trying to say, okay, who's this punishment going to go to? It's not going to the inciters. It's only going to the engagers. That's why there's no incitement language here. And it's only those who engage. So the reason they talk about that other statute is to show you how we should define the word engage, that it clearly could not include incitement. That's what Delahunty's point is here. I hope that was crystal clear to all of you. Now I got to try and find a healthy C-SPAN stream because they're stupid. So let me take care of that. No. I'm trying not to miss any chats, but StreamYard's being a bit annoying today. I'm not going to kid you. It's making it very hard for me to keep track of stuff. Normally, they track everything for me, and today they're not. I know I haven't been checking the chat, and yes, I am getting back in there because I assume that they're back soon. So let me. Let's see. It's not resumed yet, so we're not missing anything. I don't know why this thing isn't.
May be seated. You're back on, Mr. Gessler.
Thank you, Your Honor. Professor Delahunty, I've been asking you a little bit about talking about sort of certain case law to arrive at a definition of insurrection. But in your report, and I may have been going about it the wrong way and questioning you. In your report,
Man,
you talk about the difficulties
C-SPAN's
of
terrible.
interpreting Section 3's offense element and defining what it means to have engaged in an insurrection. Do you remember that?
Yes.
Okay. And
You're welcome.
when you say interpreting Section 3's offense element, what are you referring to when you say the offense element in Section 3?
Well, Section 3 has essentially 4
My pleasure.
elements. One of them, it's the language towards the end of Section 3, identifies the class of people who are subject to potential sanctions under Section 3. That, in my report, I called the jurisdictional element.
Interesting.
Then there's what I've called the offense element. And here I'm following, by the way, Professors Tillman and Blackman. The offense element defines what kind of conduct by the persons jurisdictionally subject to Section 3 have engaged in that would trigger liability. And the offense element is the language to which we referred, having engaged in rebellion or insurrection against the Constitution. Then the third element is the disqualification element, which says from what offices the persons who were subject to the section and had committed the offense in question would be thereafter excluded. And then the fourth section is the amnesty provision, which empowers Congress to extend an amnesty either individually or collectively to those who were jurisdictionally subject to Section 3 and had been found to commit the offense element and would have been excluded from the relevant offices but for the amnesty if Congress chose to give them one.
Okay. So let's focus on the offense element, which you describe as engaged in insurrection.
Mhm.
And you've looked at a number of historical sources to try and derive what that meaning is, correct?
Yeah.
Okay. And in your report, you talk about the difficulties of arriving at a conclusion, correct?
Yes.
Okay. Tell me about why you found it or currently find it very difficult to to reach a conclusion as to the offense element based on the historical sources.
Well, it's really this, that I'm not aware of any direct definition of what it means to engage in insurrection against the Constitution. I don't believe there's any case law on that. Professor Magliocco offers his interpretation of what that phrase means. And
This is
that,
why it
as I said,
clearly doesn't belong in
testified
state court.
is essentially to
Because no federal court has defined
engage
what
in,
the statute means, what this amendment means.
with the to commit insurrection against the execution of the Constitution. And that in turn is a phrase that is opaque, I would say. And really, all of the, I don't offer my own definition of what it means to engage in insurrection against the Constitution of the United States, because other than to gesture towards Senator Howard's remarks, because I don't know of any really good source to interpret that, which I think is not, my point is to underscore the difficulties a court would have, or really anybody would have, in interpreting that phrase, which is the crucial phrase, without such guidance, especially from Congress, which could define under its Section 5 powers what it means to engage in insurrection against the Constitution of the United States. Congress hasn't enacted a statute that purports to provide us with that definition. That leads me to the conclusion that the courts, as a matter of
I don't even understand this stupid
constitutional
chat.
policy,
I don't know what this means.
should defer to Congress and not decide a case on the merits of whether or not someone had engaged in insurrection against the Constitution. There's just inadequate guidance, so far as I can tell, from the relevant sources, authorities, and so on. So this is really goes, the difficulty I experience in offering a definition, although Professor Maglioka seems more confident about it, the difficulty I experience, I think, should, if only for reasons of prudence, but really sort of constitutionally inflected reasons, lead a court to abstain from deciding what that phrase means and toss the ball over to Congress to act under Section 5.
Or at the very least, the federal
Now,
government
Professor Delahunty, I'm
to
looking
decide
at
a
our
federal
court,
amendment,
who I think has a
U.S. constitutional.
inquisitorial look
interpretation.
on her face.
You're a
Now,
state
Your Honor, if
court
you have a
trying to
question,
figure
I'm
out
certainly willing to
Be the,
defer
be
for a
the
moment.
first
I'm just trying, do you have
judicial body.
examples of situations in which a court has basically said the Constitution's too hard for me to interpret, therefore I'm gonna let Congress tell me what it means?
No,
I'm just,
for the federal
in
government,
general, I think that's exactly
the
the job
federal
of the court,
judiciary
is to
should be determining
interpret
it.
the
If anyone,
Constitution. And so I'm love to hear from you as to why you think in this instance that what I need to do is
you're stepping
say
out of your lane,
it's
Judge.
too hard. Congress, tell me what it means.
No, I don't have a case law to cite. This really, it sort of broaches the question of whether Section 3 is self-executing or not. It goes more to that as sort of a prudential, or as I said, constitutionally inflected, separation of powers inflected reason.
Okay, so it's really the self-execution
Correct.
question.
Yes.
Let me ask you this, Professor Delahunty. You looked at a number of sources in an attempt to reach a meaningful definition of engage in insurrection under Article 3,
Mhm.
correct? And you looked at the prize cases. Do you remember that?
precisely that donkey.
Not in that connection, but I do remember.
But there is no
the
legal
prize
definition.
cases, yes.
Do you think the prize cases
It's
were able
ridiculous for
to
a state
give
court
you
to try to be the
sort
first
of
to define this.
confidence on what the meaning of engage in insurrection?
Well, they first of all, the prize cases, which is probably the most important Supreme Court case during the Civil War, prize cases do help with distinguishing between organized rebellion, and insurrection. So, of course, they're relevant in that connection in defining what insurrection means. It's certainly something to a degree less than rebellion. They're helpful in that way, but only so far. I mean, it doesn't explicate, because it wasn't in the Constitution at the time of the prize cases. The prize cases do not explicate what it means to engage in insurrection against the Constitution, because the 14th Amendment hadn't been ratified. That's not until July of 1868. So they're not helpful in that way. They are helpful in a general way in saying that an insurrection is different from a rebellion, and something sort of more high grade than a riot, but
Founders-
something lower.
We're very
than,
intuitive.
A
I
rebellion.
totally agree with you on that, Tina.
An insurrection, I think the court
Brilliantly
there says
intuitive.
something like, insurrections tend, in many circumstances, to lead to rebellion, but they don't have to amount to rebellion. So it helps in that way. They're sort of suggesting a gradient between rebellion,
100%.
insurrection, and other
Or
kinds of
the freedom of
disorderly
speech
conduct.
issue, really.
I'm going to ask you to stay a little bit closer to the microphone when you
Oh,
speak, Professor. Now, I suffer from the same challenge here.
Yeah.
And then you also looked at the charges in re charge to the grand jury. Correct. There was a particular case from 1894 from the Northern District of Illinois. Do you remember that?
Yeah, I think I do, yes.
Okay. And after looking at that, were you able to have any confidence of what engage in insurrection against the Constitution meant?
Well, I think that, no, not as to the meaning of that precise phrase. No, it helps to understand what insurrection meant, at least later in the 19th century.
And then you also looked at, in case of Davis, which was a federal judicial opinion, talking about how insurrection or rebellion may be committed by giving counsel to enemies or others raising insurrection. Do you remember that?
I don't have it before me, but.
As a general
Yes,
matter.
yes.
And my question really goes to all of these cases that you identified. Do they give you a sense of confidence in creating a definition of what engage in insurrection against the Constitution?
Not really. Engage in insurrection against the Constitution, only minimally. I mean, they help you understand what engage was taken to mean, what insurrection was taken to mean.
And even from the prize cases, the most you were able to glean is that insurrection is something more than a riot and something less than a rebellion.
Yeah, yes, that's right.
Okay. In your view, looking at the sources and Section 3 of the 14th Amendment, and I think you've talked about this, but how does insurrection equate to insurrection against the Constitution?
No,
And why is that?
well, self-evidently, they're different terms.
This is the part I was
And
confused about.
I
I'm glad he's going back
agree
over
with
this.
Professor Maglioka that some limiting principle should be imported into the term insurrection as used in Section 3.
So when
How are they
I
different?
understood your testimony before.
this is
to
why I was
be that the
confused. He's not
problem
clear
you
about this.
have with Professor Maglioka's opinion is that he's saying an insurrection against the Constitution is essentially an insurrection against the constitutional proceeding.
Against the execution of the Constitution.
Oh, I
execution of the
apologize.
And he offers
I accidentally referred to as aeons
And-
before, but
and
you're
that those
econs.
an
words-
example of what is and
My
what
bad.
isn't
That was on me.
such an interference with the
Yeah.
execution of the Constitution. Yes.
Right, the words execution of Constitution aren't in there. And I guess, and am I understanding what you're saying is that you don't know what what insurrection against the Constitution means without adding those extra words, and that's why you think that Congress needs to decide?
Yes.
Okay.
I think that's
Okay,
a poor.
let me,
I think that's a poor argument to make. That I think that's a weak argument.
Mercifully move on from the subject of insurrection.
Okay.
Apparently, he's not sure what the
And
difference is.
I'd
He
like
just says there's
to
a
talk a
difference.
little bit about the doctrine
It's a very
of
weak argument. And then to
or
say
the application of preemption.
preemption.
The enforcement of Section 3 by a state court.
Mhm.
And do you remember opining about that in your expert report?
Yes, I certainly do remember. This is one of the really crucial issues in this case and other cases. My report opined about the meaning of officer of the United States is used in Section 3. It opined about whether Section 3 is judicially enforceable either by state or federal courts without some enforcement implementing legislation from Congress. And then it opined about what it means in the constitutional sense to have engaged in insurrection against the United States and what difficulties there would be without congressional guidance in defining that term.
Okay, so we've covered the difficulties of defining insurrection. Let's talk about, well, let me ask you, we've got two more subjects I'd like to talk about. One is to whom Section 3 applies and whether it's enforceable or state or judicial, a state or federal judicial courts. Let's talk about the enforcement provision, if we may. Okay. There were several instances of several actions that Professor Magliocca believed constituted enforcement. Obviously, you have a different viewpoint. Why do you believe that?
Can we start just with what exactly, what provision, what clause in the article he is referring to as the enforcement?
Okay. What's the basis for your view that Section 3 is not enforceable by state or federal courts?
Well, it could be enforceable if there were appropriate legislation under Section 5. But just standing alone, I'm not really talking about a clause because...
Let's stay a little closer to the microphone. I know you're being a professor and moving about to keep the audience engaged, but I'm going to ask you to be glued to that microphone, please.
You can tell
the
that he's an
question is,
expert at keeping people
how is
engaged.
Section 3 to be enforced? Can it be enforced by a court, state or federal, independently of any action by Congress, or not? Is some enforcement mechanism that Congress provides necessary for the enforcement of Section 3? Put it simply, can I just show up at a courthouse one day and ask for Section 3 to be enforced? Or does there have to be some implementing mechanism to enforce Section 3 that Congress has provided?
And what's the basis for your opinion that as currently, based on the historical documents, that the Section 3 is, Section 3 is not enforceable absent action from Congress?
Well, my reasoning is this. First of all, as a general matter, the Constitution should not be understood to provide enforcement actions for its provisions directly, sort of taking the naked Section 3, or a case, just two cases from the Supreme Court, the Supremacy Clause, which declares that federal law is Constitution, statutes, acts of Congress, and treaties are supreme law. So in these two Supreme Court cases, the latter of which was from 2015, the court ruled that the Supremacy Clause was not directly enforceable.
And Your Honor, I'm going to object to the extent he wants to talk about historical sources. That's one thing, but to the extent that he wants to talk about his interpretation of contemporary judicial precedent, I don't think that is proper here.
I think we'll be able to tie it up, but I'm certainly happy to start with a different approach, Your Honor.
Okay, because I tend to agree with Mr. Murray. So I'm going to sustain that objection.
Okay. Looking at the historical record, I believe that you referred at one point in your report to and as has Professor Magliocca, the Griffin's case.
Yeah.
Okay. Could you explain how that's relevant to the self or non-self executing nature of the 14th Amendment, Section 3?
Section 3. Well, the Griffin case is decided not so long after the 14th Amendment, including Section 3, is ratified. And I think it helps us to understand what, in the mind of the framers and ratifiers of voters generally, Section 3 was understood to mean. And it's an opinion by the Chief Justice of the United States, Samuel Chase, that addresses the question of whether Section 3 can be directly enforceable without implementing legislation, or whether implementing legislation is required. That's one of the three bases of Chase's opinion. And Chase was not only the chief, it's not an opinion for the Supreme Court. It's an opinion by Chief Justice Chase, writing circuit. But it's soon after the Section 3 is ratified and put into the Constitution, and it's by someone who was not only Chief Justice, but a very fine lawyer and a politician and potential candidate for the presidency at the time. And it's soon after the ratification of Section 3. So I think it's weighty authority as to what Section 3 does and does not do in the absence of action by Congress under Section 5, the enforcement provision of the 14th Amendment. And Chase holds that it's one of his three holdings that Section 3 is not directly judicially enforceable. And that strikes me as very powerful evidence. I'm not saying it's a binding precedent. I mean, for one thing, it's by a justice of the Supreme Court alone. It's not a decision of the Supreme Court. But it strikes me as very powerful evidence as to the original public understanding of what Section 3 did. And there was consideration given in Congress even before Chase's opinion in Griffin's case. There was consideration about the need to enforce Section 3 by acting under Section 5. And that ripened into enactment in 1870, after Chase's opinion, the enactment of the Enforcement Act of 1870. So Congress took the signal from Chase that Section 3 needed enforcement. There were other
after Lincoln was
reasons even
killed,
before Chase to think that it needed enforcement. And Thaddeus Stevens, who was the departing Speaker of the House, told the House it needed to step up to the plate and provide legislative mechanisms to enforce Section 3. But it is relevant to a question before the court here of whether it can, without congressional action, decide whether to reach the merits or whether it needs some congressional action before it does it. This applies to both state and federal courts. Now, the Worthy case, I think you mentioned that, and it's certainly pretty prominent in Professor Maglioca's testimony. The Worthy case is a North Carolina case which is decided before Griffin's case, doesn't take account of it, certainly doesn't undercut Chase's opinion because it's the Worthy case is decided in January of 1869. Chase's opinion comes down in late July of 1869. If I were a judge in North Carolina and knew of and had studied Chase's opinion in Griffin's case, I would have discussed it in my opinion in Worthy. Had Worthy come, say, 6 months after Griffin's case, I would certainly have taken account, positively or negatively, but I would have taken account of what the Chief Justice of the United States had said in Griffin.
What was the Worthy case about? Was that actually a direct interpretation of the U.S. Constitution?
Well, as I read it, the North Carolina court is acting under a North Carolina statute that incorporates and makes state law qualifications based on Section 3. It's not direct enforcement of Section 3 per se. It's enforcement of a state statute that takes Section 3, incorporates it, and applies it to state officials and state offices, which, of course, a state can do. A state can rule on the qualifications or disabilities or whatever of its own state government officials. That it can do. And I think that's what North Carolina did or was attempting to do. So as to whether globally Section 3 per se is self-enforcing, I don't think Worthy has much, or I don't think it has any real relevance. If you parse out that case closely, I think you see it's acting under North Carolina statute.
Now, shortly after Chief Justice Chase issued a decision in the Griffiths case with respect to the self-executing nature, he also ruled in another case, a second Griffiths case that was, I believe Professor Maglioka and others have stated contradicts his earlier viewpoint on, or his earlier ruling on self-execution. Can you address that, please?
Yeah, the argument that Professor Maglioka and others make is that Chase took inconsistent positions on the enforceability of Section 3 in the Jefferson Davis case from what he said in Griffin's case. First of all, I would say it's not absolutely clear what Chase said or wrote in.
So the Griffin case was decided individually.
The Davis case, that's a dispute among scholars, but I'm going to assume that
by Salmon Chase,
the view and that
it was the Supreme Court Chief Justice
in the Jefferson Davis case,
1867.
Section 3 was not self-executing. So let's posit that there was a contradiction between Chase in Jefferson Davis and Chase in Griffin. Let's posit that. I don't think that matters because judges, professors can change their minds. And maybe he did. But the real thing
I'll explain the
to look at is
significance
quality
of the
his judicial
self-executing
reasoning
issue they're talking about.
in Griffin's case.
When
We
there's
don't really have an account of any judicial reasoning he may or may not have had in Jefferson Davis's case. So we do have this leading authority in Griffin's case by the Chief Justice. If he's trapped in some kind of contradiction, does that really matter? Look at the quality of the reasoning in Griffin's case. In any event, even if we do catch Chase in some kind of opposition, contradiction, I think, even if we think we have, I would say that the two cases are reconcilable because Jefferson Davis's legal counsel appeared to have been threatening to use Section 3 as a defense in Jefferson Davis's, it never happened, but in his forthcoming trial on violating the federal treason statute. So that would have been a defensive use of Section 3. And maybe Section 3 can be used defensively against a charge of criminal treason. I'm just not sure about that. We don't have any ruling because what happened with Jefferson Davis was that President Johnson pardoned him and that short-circuited any trial. It just didn't occur, never happened. Pardoned him from the charge of having committed the federal crime of treason. So Davis's lawyers said that they were planning to use Section 3 as a shield defensively to, they sort of thought that Section 3 had displaced or overcome the treason statute in his respect. Whereas in Griffin, Chase was really saying that Section 3 could not independently, directly be used as a sword on which to base a claim to affirmative relief. And the plaintiff, he was a prisoner, was seeking federal habeas relief, so affirmative relief, based on Section 3. That would be using Section 3 as a sword. And Chase reasoned it's not self-executing in that sense. And that opinion, Chase's opinion in Griffin's case, was cited affirmatively, and even
Arguably, yeah.
the sword shield distinction in it was approved of in a 1979 Fourth Circuit opinion. So Chase's view about the way in which Section 3 was non-self-executing, Chase's view was considered good law until, at least until 1979. I think it's good law, but so what? But certainly in the minds of federal courts, it was good law as late as 1979. That case is called Cole versus City of Covington.
Okay. Did you
I think you need to land your plane.
Did you come
Kelsey.
across any historical documents or analysis that leads you to conclude that Congress embraced Chase's interpretation of
I think so. The question whether various iterations of Section 3 would be self-enforcing or not came before Congress actually pretty early in the process of ratifying Section 3.
I agree with you. It would be a very shrewd move.
Stevens, who was kind of the leader in the House of the
Very
radical
shrewd move.
Republicans, said the version of Section 3
But
he
it's
preferred
beyond him. for the
would
Democrats to do that.
need congressional implementation. He reiterated that when leaving Congress in 1868. There's that. But after Chase, now to my knowledge, there's no mention explicitly of Griffin in Congress after it came down. But I think it's reasonably safe to assume that Congress, after 1869, was aware of an opinion of the Chief Justice of the United States. Much more likely that they knew of, in Griffin's case, than they knew of Worthy's case. After that, Congress decided, yes, we will enact implementing legislation that kind of reinforces Chase's view, because it provided in the Enforcement Act of 1870 a mechanism by which a federal district attorney could, in certain cases, bring Section 3 cases against, in court, against certain covered officials. They accepted senators and members of the House, but against another class of officials, the federal district attorney was authorized by this federal statute to bring enforcement actions in federal courts alone. So that was how, as I see it, Congress responded to Chase, even though, to my knowledge, it didn't explicitly, nobody in the debates that I've seen explicitly refer to Griffin.
So your view is that congressional enactment, the Congress enacted implementing legislation for Section 3.
Pretty soon after, yeah.
And so sort of based on your approach to this historical analysis, your view is that they knew about the Griffin's case or were likely to have known about it?
Yes.
And why is that?
Well, it's an opinion by the Chief Justice.
Okay.
So.
He went
un-
easy on Trump.
Under
That's why he's
this
going easy on it.
theory, essentially, wouldn't it put the question of whether whether this provision of the 14th Amendment is even exists, right? I mean, on Congress. So I mean, it's essentially giving Congress the power to decide what amendments to apply or not apply.
Well, if they're going to be applied.
Could you please move?
Sorry, I'm so sorry.
I'm sorry.
If they're going to be applied as sorts to seek affirmative relief, I think this action, it doesn't originate with, this congressional interest doesn't originate with Griffin's case, but it maybe is prompted by Griffin's case, and it, I think, corroborates, reinforces Chase's conclusion that Section 3 is not self-executing, is used in that way.
But my question was just a little bit different,
Okay.
which is if the only way to enforce a constitutional provision such as this is through legislation, then essentially isn't it leaving to Congress to decide whether or not the prohibition exists at all?
Yes, I mean, unless you try to implement it in the way North Carolina did through a state statute that incorporates Section 3 by reference. But I really want to be responsive to your question,
No,
Your Honor, but
that was.
yes, I mean, and in fact, I think Stevens at the time basically was saying, I mean, even earlier than Chase, Stevens was saying, hey, Section 3 is a dead letter. It's a dead letter unless we provide some enforcement mechanism. And, you know, generally speaking, Congress at the time wanted to take charge of the Reconstruction program. And so I think people like Stevens were saying, we want to decide how and when and whether to enforce Section 3 or leave it to be a dead letter. Obviously, Stevens thought that that was a very poor idea, but that's what he was saying. He was warning his colleagues, we can't let this stay a dead letter. And so in the Enforcement Act of 1870, they basically said, we're going to leave it a dead letter, at least for now, as applied to people like us, members of Congress. But we're going to make it a live letter when applied to another group of people who aren't in Congress. There was that threat that it would be a dead letter and not judicially enforceable.
In your opinion is today it's a dead letter? It's essentially.
No. My opinion is that it is not judicially enforceable absent either incorporation as applied to state officials, which is what North Carolina did, or it's not enforceable offensively without an act of Congress, without implementing legislation.
So if Colorado had a statute that adopted Section 3 of the 14th Amendment, is your opinion that then it would be enforceable?
It would be enforceable in Colorado as applied to state officials, candidates, state offices. Outside of that, I think it's not applicable by state law of Colorado.
So at a federal level, your opinion is that Section 3 of the 14th Amendment is a dead letter, essentially, a non-existent constitutional provision because there's no way to enforce it?
Well, no, I don't think it's a total dead letter. We don't know whether it could have been used defensively, as Jefferson Davis tried to do, or not. But it, like much of the 14th Amendment, it requires congressional action to provide the course of action in a court. There's just this. Can I? Sorry.
Go ahead. No, I'm just
So,
trying to make sure I
The
understand
baseline.
the testimony.
Professor Delahunty, I'm going to ask you to wait until the sirens go by.
Mhm.
Oh, okay.
That's one of the unique characteristics of this courtroom.
Okay. May I proceed?
Yes.
So the baseline for understanding the Constitution globally is set by the Supreme Court in these supremacy clause cases that I mentioned earlier. That's the default position. The Constitution generally, globally, whether it's Section 3 or the supremacy clause, the Constitution is not self-enforcing in the relevant sense. And the court in the latter of these two cases, the Armstrong case,
This is similar to what they said in
Constitution
Trump's
is
team said in
not
Minnesota.
automatically self-enforcing, why it needs
I don't love this.
guidance. And that is
argument.
because Congress
I'll
has to set
explain
the
why.
policy of the United States and can
I think they're getting
decide
lunch
whether and how far to
when they go to lunch. I'll
enforce
explain why.
constitutional provisions and whether or not to. That's the general assumption. The Constitution as a general matter is not self-enforcing. So that's the Armstrong case.
Okay. You gonna do lunch now?
Your Honor, may I continue or do you have?
No, of course. I'm sorry to interrupt.
So let me ask you about historical examples of Congress refusing to seat members for whether
Over there, I
viewed as
forgot.
treasonous
12:15. They go to
or
2.
rebellious or types of behavior that would fall under the ambit of Section 3.
They're gonna be here a
Are
while
those
more.
examples of congressional enforcement of Section 3?
Well, I don't think they are because if I recollect that part of Professor Magliocca's report, these two exclusions occurred before Section 3 was ratified. So in that way, they're not. Congress has the power to exclude members elect, and that power is a limited one under Powell versus McCormick, but maybe in this relevant period, close to the ratification of Section 3, Congress took a broad view of its powers to exclude members elect and acted under the provisions in Article 1 rather than the 14th Amendment, enabling it to exclude members elect
Okay.
for good cause. Now, that's been tightened, the exclusionary powers of Congress. We don't know. The Supreme Court in Powell versus McCormick specifically withheld opining on the question whether Section 3 is a disqualification and a basis for congressional exclusion. It withheld that judgment.
Okay. Let me excuse me one moment, Your Honor. I just need to look at something.
So, Economath points out that Section 5 of the 14th Amendment, which is here, Congress shall have the power to enforce by appropriate legislation the provisions of this article. That's the entire 14th Amendment, including Section 3, which is the part that we're all fixating on for the past week.
Let me move on to
And that's probably why they keep coming to this.
Here. Were you able to identify any instances in the historical record of your view where Section 3 was enforced by state officials in state courts? Not a state incorporation into state statute of Section 3 standards, but Section 3 itself directly enforced by state courts.
No.
Okay.
See, and here's the problem with that argument that you're making. Because there are other
Let's move
parts
on
of the 14th
to
Amendment
the
which are handled by
third
court
item that
all
you
the
had
time.
discussed in your
The
test.
due process
in your,
clause of the 14th Amendment is handled by Congress,
report,
by
in your opinion,
judiciary all
with
the time.
respect to an officer of the United States.
Mhm.
It cannot
Although
be
before we move
exclusively
there,
Congress.
is there anything else
It's a weak argument in that sense.
that serves as the basis for your opinion that Section 3 is not self-executing?
Well, I've given the basic reasons, including the Fourth Circuit's reference to and reliance on Chase and application of les schema, the framework of Chase, to the case before it, which was a wrongful discharge action based on an assumed cause of action directly under the 14th Amendment.
Okay. Let's talk about the phrase officer of the United States.
Well, I'm sorry.
Let me ask a question and then we'll head there. So what's your response or your opinion on Professor Magliocca's conclusions that an officer, the phrase officer of the United States as used in Section 3 includes the president and vice president of the United States?
Well, I disagree with that conclusion. And the more I looked into that question, the more I was persuaded that he is really wrong. I think that that term is, in essence, a term of art and had a specialized meaning. And this leads me back to the question of whether I had consulted legal dictionaries, like dictionaries, like Noah Webster on the meaning of insurrection. There is a legal concordance. Now, is that a dictionary? It operates, it looks like a dictionary. It's from 1883, I think, by John Lawler. And it offers legal definitions of various terms, including the term officer, and it cites supporting case law for its definition. That definition of officer has a separate, compartmentalized understanding, definition of officer of the United States. Okay, now this is 1883. It's later than the ratification of Section 3, but it's not too long after the conclusion of the Reconstruction period, which is commonly dated to 1876, the election of President Hayes. And so I think it's fair to say that officer of the United States was understood by the legal community, the kind of people who would have read this concordance, looked up the definitions it offers. I think it's fair to say that officer of the United States was understood to be a special term needing separate definition from officer generally.
And so what sources, other sources did you look to define what officer of the United States means?
Well, there is the language, the text of the Constitution itself, and then there are a long variety of Supreme Court opinions going up to a fairly recent one by Chief Justice John Roberts, defining what officer of the United States means for purposes of the Appointments Clause in Section 2. Some of these Appointments Clause cases are roughly around the time of the ratification of Section 3, and they include lower court federal cases about the definition of the term officer of the United States. And of course, it or very close cognates to it appear in the text of the Constitution itself. And so far as possible, one wants to construe these constitutional uses of the term officer of the United States to be consistent, to be the same. So the text of the Constitution uses the term in several contexts, and the meaning should, by ordinary rules of construction, be consistent from one such provision to the next. So I think both the text of the Constitution, especially if you assume this rule of consistent meaning in different uses, the text of the Constitution and the Supreme Court case law support the view, strongly support the view, that the term officer of the United States means the same thing in Section 3 as it means under the Appointments Clause. That the Appointments Clause is kind of the anchorage, if I may speak that way, of interpreting the meaning of this phrase, officer of the United States. Elsewhere in the Constitution, outside the Appointments Clause, including Section 3.
And why is it considered the anchorage?
Well, because of the principle, because they're case law, Supreme Court case law, some of it very recent, but also because if the term is to be used in a consistent way through the text of the Constitution, then it's got to mean elsewhere what it means under the Appointments Clause.
Now, did you also look at the impeachment clause and the drafting documents involving the drafting of the impeachment clause as part of your opinion?
I don't know that I looked directly, I mean, I didn't look closely anyway at the document. Other than it's cited in court opinions, I don't think I looked at the original pre-1788 documents. No. Did I look at the case law? Yes. And the case law, I did consult secondary sources about the process of drafting the impeachment clauses, and the secondary sources show, I think, that as used in those clauses, the officer of the United States had a meaning that was designed to exclude the president. There's separate rules about presidential impeachments from impeachments of lower executive level officials and federal judicial officials. There's a separate treatment of those officials in the impeachment clause. Says.
Okay. Let me, you also talked a bit about the, with respect to the jurisdictional language of Section 3 involving the oath clause. I'm sorry, we've talked about that in Article 6. Are there any other documents or bases of your opinion that an officer of the United States excludes the president and vice president?
Well, I think the language that the Constitution uses for describing an Article 6 oath is strikingly different.
I think the argument,
from the language.
I think that's a strong argument saying that the Constitution is consistent in how they use terminology.
Presidential oath.
So if officer of the United States in the
Article
Constitution
2 of the Constitution, there are two
has a certain
oath clauses, an Article
limitation
6
excluding the president,
and an Article 2 one.
That's pretty compelling.
Okay?
And when it's used in an amendment,
Section
they use
3
that
of the 14th
specific
Amendment
phrase in
echoes the
That's what it means.
language of Article 6, where those who are subject to it have to take an oath to support the Constitution. If you go back to Section 3 from the oath clause in Section 6, it appears quite obvious to me that they were talking about the class of people who had to take the Article 6 oath, not the people who were talking, that they didn't mean to include the Article 2 oath clause. I think that's, now, as Professor Maglioka says that, and he cites a grand jury charge from the 19th century that allows for some play in the joints as to what it means to take an oath to support the Constitution. There can be, his historical source says, some play in the joints, some elasticity. But so what? That doesn't assimilate the Article 6 language, where the president has to swear to preserve, protect, and whatever else it says, the Constitution, You can't just assimilate the language of the Article 2 oath clause into the language of the Article 6 oath clause. That's beyond play in the joints. It's a separate language about how what the president's constitutional responsibilities are.
Now, how do you respond? And I believe Professor Maglioka said, look, an oath to protect and defend is essentially an oath to support. So they're effectively the same
Well, I think
thing.
that's stretching the language much too far. I mean, people who draft constitutional language have to be very, very careful about the terms they use, especially if those terms are embedded elsewhere in the text of the Constitution. So I think he's going way too far. I once at OLC was tasked with trying to draft an amendment to the Constitution, and we gave up in the end. It was so hard.
And what's the basis for your opinion that people who
That's funny.
draft
That's
the
funny. Totally
draft
offensive to the
constitutional
Native
provisions
American
are
people.
very, very careful about the language they use?
What's the basis for my opinion?
Yes, and if you could explain to
sorry.
me the basis in the microphone, that would be great.
Yes. Well, look, there's a principle that Professor Keelamar discusses at length in an article called, I think, intertextuality or maybe intratextuality, where he shows that you should, if you are asked to, interpret the same term in different occurrences in the Constitution in the same consistent way.
And Your Honor, I'm just going to object to the extent that we're talking about canons of construction among modern scholars as opposed to historical sources.
Sustained.
Okay. So let me ask you, did, as a matter of historical analysis and knowledge, did the people who drafted Amendment 14, did they take care about the language they used and understand when they used language that mimicked other language or was different than other language? Let me try.
Well, the drafting of section,
Why don't you ask him?
That was a terrible question that I was about to say.
I'm going to sustain your own,
I mean,
to your question.
No, I'm not objecting to my question, Your Honor. I'm simply withdrawing it. So in using the term officer of the United States or using an oath to support versus a different type of oath, the care and usage of language, did the framers of the 14th Amendment pay conscious attention to the very specific words they were using and how that did or did not reflect
Attention leading.
other usage in other parts of the Constitution?
well, the initiative to draft a new amendment to the Constitution came very early after the Civil War because it was considered generally, widely, that there was need to bring the Constitution up to date, and in particular, a need to get rid of Dred Scott and its holding on citizenship. So the Congress, very, very early in its term, set up a 15-member joint committee, including members of the House and Senate, to do exactly that. They included some very fine lawyers and very thoughtful people. And the committee considered several draft versions of what later matures into the 14th Amendment, including Section 3. And those proposals, which ripened over months by leading members of both houses, then are presented to the House and Senate for consideration, again, by very able lawyers. And do I have that somebody sat down one day in the course of these deliberations and said, we got to make sure that everything clicks into place? No. Do I make the assumption based on the care and length of the deliberations that the special select committee and houses gave and the attention that was given to it to determine exactly who is covered, who is jurisdictionally subject? Do I make the assumption that that was given careful consideration to bring it into line with the rest of the Constitution, or else depart from the standard meaning? Yes, that is an assumption I would make.
I'm not a scholar.
I have no further questions.
I'm not a scholar.
Your Honor, if you have any further questions, we're certainly
Oh, I was-
appreciate the discourse that
No,
you may
thank you.
have.
I was just wondering, Professor Magliocca, he showed us some discussion about the enactment of Section 3 of the 14th Amendment, in which one of the senators stated, don't we want to make sure that this applies to the president? And then somebody responded and said, well, it applies in the kind of catch-all phrase. And then the gentleman says, oh yeah, I see, you're right. So how does that discourse, which
That colloquy,
impact your opinion in this?
that Senate colloquy between Senator Beverly Johnson of Maryland and Senator, I can never remember whether it's Merrill Lott or Lott Merrill, I think it's Merrill Lott of Maine. That colloquy concerns the disqualification clause of Section 3, not the
I made that same argument
jurisdictional
before,
clause.
Charles.
So it is relevant
I agree with you.
to interpreting from what offices a covered person who has committed the relevant offense will be excluded. That's the start of the language in Section 3. But it doesn't go to the coverage of the jurisdictional coverage of Section 3. You can't just map on the leading language of Section 3 about from what offices shall this person be excluded onto who is covered by Section 3. It goes more to whether the presidency as an office is included in Section 3. Then it goes to the question whether the president is or is not an officer of the United States. So I don't think it's relevant, frankly, to the interpretation of the judicial, the jurisdictional aspect of Section 3.
Thank you, I appreciate that.
Your Honor, we have no further questions, and with that, we will release the witness to opposing counsel for cross. Although I know it's about 11:30.
Yeah, so let's just talk for a second about timing. I know that we were planning on having Mr. Heafy at 1. Is that like a hard time, or does Mr. Heafy have some flexibility in his schedule?
Mr. Grimsley can talk about his schedule.
Your Honor, that's a pretty hard time for him. He teaches class in the evening and he's on the East Coast, so that's 3 o'clock for him, his time.
Okay.
So I think it would be fine with us to take him out of order. And just as much as I don't want to interrupt the cross-examination, I think it would make sense to do so.
And I guess the question for you, Professor Delahunty, is are you available to finish your cross-examination after we take this other witness, or are you available today?
So they're going to take
Today,
Heafy now?
yes.
Okay, it would be today. We may go till noon and then break for lunch, do Mr. Heafy and come back to you sometime later in the afternoon. Is that okay with you?
We're not supposed to
Yes.
be doing Heafy
Okay.
today.
So let's do about a half hour of cross-examination, and if you aren't finished, we'll finish it after Mr. Heafy.
Yes, Your Honor, thank you. Let me just make sure you've got me up on the screens. Looks like we're on this one, but not this one.
You may proceed.
Good morning, Mr. Delahunty. You're not claiming to be an expert in the history of Section 3 of the 14th Amendment, are
No.
you? And certainly Section 3 of the 14th Amendment is not the main focus of your scholarly work,
That's
correct?
true. It has been for very few academics until recently.
I want to look briefly at some
Good
of the
counter. No
things
one
that
was
you
an expert
have
on it.
published
Until 10
academic
minutes
literature
ago.
on. This is Petitioner's Exhibit 315. Is this your latest CV?
Yes, I think it is. I did ask council to submit a slightly updated CV.
Yes, and this is the one we received,
Okay.
I believe, on Wednesday.
Yes,
of this
okay.
week. On page 3 of your CV, we have some articles and book chapters here, and one of those is a book chapter deconstructing the deep state
Yes.
in the book Up from Conservatism. Do you
Yes,
see
that's
that?
right, yes.
And you've also written on, for example, the major questions doctrine and the administrative state.
Yes,
You mentioned some publications on Shakespeare. Is this one of them here?
yes,
And at the bottom, there's another one about Shakespeare's King Henry and Just War. Is that right?
yes,
You have a lot of publications on foreign affairs and international law, such as Toward a Concert of Asia and the Crimean Crisis and the use of weaponized drones. Is that right?
well, the first one was accepted for publication, and then I think this publication by the university, by a journal at the University of Pennsylvania was never actually published. It wasn't rejected. I think they just closed down. But yes, in that sense, it was
But those are-
accepted for publication, yes.
And those are things you wrote.
Well, it never got published. I don't know exactly what you mean by it. It's a big zero, but
Do you mind just speaking a little bit closer to the
I
microphone? Thank you.
I mean, I think I gave full disclosure. It was accepted for publication, but was not published.
And
Does
nothing.
that make it a big zero? I
Oh.
don't understand. the question.
Oh, no, I'm sorry. I may have misspoke. But let me ask you another question. Nothing on this page of your CV relates at all to Section 3 of the 14th
No,
Amendment. Is
that's
that right?
certainly true.
And I'm not going to go through every item in your CV, but just on the next page, we do have some additional articles on things like international law, the laws of war, the Bush Doctrine, Latin America, things like that, correct?
Yes.
And again, there's nothing on this page, no publications that relate to Section 3 of the 14th
No.
Amendment.
No.
On the next page of your CV, once again, there's articles on international relations, on the Kosovo crisis, on why American and European attitudes towards international law differ, on against foreign
This
law,
lawyer,
and
yeah.
things like that, correct?
Yes.
And again, on this,
Also, if I may say, the piece about against foreign law is about constitutional adjudication and whether foreign law should be imported into the interpretation of constitutional clauses.
understood. And in your article against foreign law, you weren't discussing Section 3 of the 14th
No,
Amendment.
no.
So the whole nature of cross-examination is that they're usually yes or no answers.
Right.
And you kind of know where he's going, so you're tempted
Yes.
to answer before he finishes, but you gotta wait just for the court record, okay?
Okay.
And if we go to the next page of your CV, we have a few more articles on things like the Geneva Convention and the president's authority to conduct, constitutional authority to conduct military operations and foreign affairs matters. Is that correct?
Yes.
You've also written on philosophy. For example, you have an article about Descartes, correct?
Yes.
And you've written a book on the philosopher Baruch Spinoza, true?
Yes.
You've never written a book with a central focus on the history of the 14th Amendment,
No.
have you?
No.
These days, you write a lot of political commentary, is that right?
Yes.
For example, you write articles and op-eds in Fox News and the National Review and the Federalist.
Yes.
For example, you wrote an article with John Yoo entitled Pushing Back on Cancel Culture. Do you see that?
Yes.
And on the next page, you have a number of articles about China and COVID, such as how to make China pay for COVID-19, correct?
Yes.
And if we go a few pages down the line, there's articles about things like the South Korean election, the Persian Gambit, and Brexit, correct?
Yes,
Do you remember writing an article in the Federalist this summer about why, in your view, Democrats can't ditch Biden?
yes,
In that article, you claimed that Biden was suffering from what you called embarrassingly obvious cognitive decline. Is that right?
yes,
In that article, you said
Relevance.
that President Biden is surrounded by the stench of corruption,
Yep.
and you cited evidence from, quote, the Hunter Biden laptop. Do you remember that?
yes,
This guy thinks he's scoring
In that
points with
article,
this?
you also discussed, quote, the pouch of cocaine found in Biden's White House. Do you remember that?
yes,
And in that article, you referred to the Democrats and their deep state enforcers in the FBI and CIA. Do you recall that as well?
yes.
You've never written a peer-reviewed article with a primary focus on the history of the 14th Amendment. Is that right?
That's
This is
right.
the hubris of the
You've never
Ivy
published a
League.
peer-reviewed
You're not
article
one of us.
about Section 3. of
You're
the
not
14th
one of
Amendment,
us.
No,
correct?
I have not.
You're not
And you have
one of
published
us.
one article talking about Section 3. Is that right?
Yes, an op-ed.
That was an op-ed in the Federalist in August of this year.
That's right.
You'll agree with me that your op-ed in the Federalist was not a work of historical scholarship, right?
That's right.
It doesn't cite very many historical primary sources.
No,
You've never given expert testimony before, correct?
correct.
I want to ask you a few questions about historical methodology. When you're doing historical work, I think you said on direct that you look at primary sources, correct?
Yes,
And it's always better to go back and look at the original primary sources than it is to take some secondary sources' word for what those primary
that
sources
is
say.
correct.
Were any of the sources that you discussed on direct examination sources that were uncovered through your own original archival research?
No,
In your report, you said that you gave a draft of your report to Professors Blackman and Tillman. Do you recall that?
that's right.
And you said that you gave Professors Blackman and Tillman a draft of your report because they have, quote, written extensively on the subjects discussed in my report,
Yeah.
right? Unlike you, Blackman and Tillman have written extensively on the subject of whether the president is an officer of the United States under Section 3 of the 14th
That
Amendment.
is correct.
But you know that not all scholars agree with that view, right?
I do.
Blackman
You know
agrees
that
with him. I think.
Professors William Bode and Michael Paulson disagree with that view.
I certainly do.
Did you ever ask Professors Bode or Paulson to comment on your draft report?
No,
Because they're idiots.
You know that Mark Graber disagrees with the Blackman and Tillman view that the president is not an officer of the United States, right?
well, I haven't read.
This is
the
so
Graeber
stupid. You're
piece.
trying to appeal to authority. It's a
Um,
logical
but
fallacy.
I
We
assume
all know
that
that's a
he is
logical
indeed
fallacy. Say
Um,
this
or
person says it, that person
disagreement,
says it.
rather, with Tillman and Blackman.
You haven't read Mark Graber's piece discussing the history of Section 3 of the 14th Amendment.
No,
Nobody looked at
And so
Section
you
3 of
never
the
asked
14th
Mark
Amendment
Graber to comment on your draft report
more
either.
than 3 years ago.
Did you ever give a draft of your report to John Vlahopoulos?
no.
Do you know who that is?
Yes, I've seen references.
This is what
to
Tara
his
Rayner keeps
recent
saying.
work.
He also wrote an entire article responding to the Blackman and Tillman position that the president is not an officer under Section 3, right?
I didn't know that, but yes.
You didn't know about that article and you didn't read
No.
the article where John Vlahopoulos responds directly to the Blackman and Tillman position in the
No.
context of Section 3.
No,
Ooh, someone responded to
You
it.
didn't solicit comments from any scholars who disagree with your opinion on whether the president is an officer of the United States. I want to ask you about some of the sources you do rely on. I want to pull up your report. Petitioners Exhibit 227.
Because petitioners are relying on
And
these
does this
fourth
appear to be
source
the expert report that you served in this
Ivy
case?
League arrogant,
Do you recall that in your expert report,
peer
you have
reviewed?
starting on page 5, a
Scholar.
background to Section 3 of the 14th Amendment?
yes,
And if we scroll through, just that section is about 7 pages long, and it goes until page 12 of your report.
Yes,
In that entire section, you don't cite a single primary source, do you, sir?
You called me a
think so,
scholar.
no.
That's why I said I'm not a scholar.
You do cite to Professor Kurt Lash's recent article on Section 3, though, right?
yes, yes.
I'm too smart
And-
to be a scholar.
Certainly, you don't cite any original historical research that you've
No,
done.
not on the background. No,
And in this article by Kurt Lash, that's your only citation in your background section. That's a draft paper that hasn't been published yet,
that's
right?
right.
That was actually posted on SSRN just a few weeks ago.
That's right.
I want to look briefly at Professor Lash's draft paper. Petitioner's Exhibit 289.
I read it late last night, that portion.
Does this appear to be the article from Professor Lash that you relied on?
It does.
If we go to page
I don't think
3
it's
of Professor
dispositive of
Lash's
anything.
article, there's a footnote here, footnote 5, and it says a robust scholarly debate has
Influential,
emerged
not dispositive.
regarding the proper reading of Section 3 terms,
Could be that
such as office and officer, and those who have previously taken an oath as an officer of the United States. Do you see that?
Yes,
it could be that
And then
they were
he
the only
cites
two
a number of
people who heard
scholars,
that
right?
part of the conversation.
And some of the scholars he cites are Josh Blackman and Seth Barrett Tillman, who you said you sent your draft report to, right?
yes,
He also cites William Bode and Michael Paulson, right?
yes,
And he also cites Mark Graber, whose paper you said you never read, correct?
You mean that particular citation? I have not read his piece in lawfare, no.
Oh,
He
you're
also
smart.
cites as a contributor to this robust scholarly debate,
I accept your
Gerard
apology.
Magliocca, who you understand is petitioner's expert in this case, who testified earlier this week, correct?
Yes, yes.
Thank you, Kelly.
Professor Lash does not list you as having made any contributions to the robust scholarly debate.
Who
about the proper
cares?
meaning of
That's
office
appealing to
and
authority.
officer under
Who
Section
cares?
3, is that right?
That's right.
If we go to page 48, there's another footnote, and it's a long footnote. I'm not going to ask about the substance of what the sources are talking about, but I just want to ask you, do you see in footnote 218, Professor Lash cites an opinion reported in the Times-Picayune
Yeah.
and a jury charge
Yeah.
reported in the Tennessean?
Yes,
And at the end of that footnote, Professor Lash says, "My thanks to Gerard Magliocca for the pointer to these opinions," correct?
yes.
Yeah, and this
Nowhere in Professor Lash's article
the
is there an
circle
acknowledgement
of
given to
jerk.
you for any contribution that you've made to the
It's a
historical
complete
record on Section 3,
circle.
correct?
That is correct.
And in fact, Professor Lash's
It's
article
so
doesn't cite you
very tight.
anywhere in his draft article. Is
No,
that
he
right?
does not.
The circle.
Your Honor, at this point, we would renew our motion to exclude the testimony under Section 702.
Yeah, he's not in this circle, jerk.
I'm going to deny the motion. As I said, Professor Delahunty has expertise in reviewing historical documents and applying them to constitutional provisions, and his lack of scholarly contribution to Section 3 in particular, I don't think excludes him from testifying on the opinions that he's testified to today.
When they go to lunch, I'm going to give you my
Thank you,
final
Your Honor. At this
opinion
point, I'm going to
of the
move on to
week
the substance
of
of
the
his
different
opinions,
parties
but I
here.
know we only have a few minutes left, so I wanted to see if you wanted me to start with that, or
Okay,
if we want
thoughts
to
on this
just
whole
break
thing.
for lunch now.
Why don't you start, just since we're running a little bit behind today? We'll go for about 10, 15 minutes and maybe take a little bit shorter lunch.
Sure.
You suck, Judge.
Mr. Delahunty, I believe you said on direct that the 14th Amendment was, that you begin your constitutional law classes with the 14th Amendment. Is that right?
Yes.
And you called,
Actually, that's probably what I said. I began it with Dred Scott typically.
Dred Scott and then a discussion of
Correct.
the 14th Amendment?
Yes,
And you referred to the 14th Amendment as a second founding of
Yes.
our Constitution. Is that right?
Yes,
The 14th Amendment is not some kind of second class constitutional amendment. You'd agree with that, right?
I do. Although, well, I wouldn't. I don't think you can make it. May I ask for clarification of the question?
You can ask him to repeat the question, but I'm just going to admonish you again to let him finish his questions before you start to answer.
Okay. I don't understand the distinction you're trying to draw, counsel, between first class and second class amendments.
Well, I'm not sure I do either. I'm just trying to make the point that
I don't know what I'm asking
there's
myself.
nothing that says that the 14th Amendment is somehow lesser than any other constitutional amendment,
That's
right?
right. They stand on an equal plane.
So I want to start by talking about your opinion that Section 3 is ambiguous and that therefore it needs congressional enforcement legislation. You'd agree with me that courts interpret ambiguous text all the time, right?
Indeed.
Courts interpret unreasonable searches and seizures in the Fourth Amendment, for example.
That's correct.
And even in the 14th Amendment, they interpret terms like due process and equal protection, correct?
Yes.
Are you aware of judicial decisions saying that we can't tell what an unreasonable search and seizure is or due process of law is unless Congress tells us?
No, I'm not aware of any such decisions.
When you teach constitutional law, do you teach Marbury v. Madison?
Yes.
And that's a case where the Supreme Court, Chief Justice John Marshall said it's emphatically the province of the judicial branch to say what the law is, right?
It is, yes.
You know that courts interpreted and applied Section 3 pursuant to state law even before Congress enacted implementing legislation.
That's true.
Your opinion, one of your opinions is that it's difficult to understand how the phrase insurrection was defined during Reconstruction, correct?
Well, I don't know that it was defined at all, but it is difficult to interpret the term.
They clearly thought anyone
But
who
you agree with
participated for the
petitioners
South in the
that
Civil War
Section
was an
3
insurrectionist.
remains in force even outside the context of the Civil War.
I do agree with that. And so state in the report.
And you agree that Section 3 has continuing relevance to any future insurrection or
I
rebellion.
do agree with that, yes.
You also agree that
Because
insurrection
no one else is covering it.
need not rise to the level of
No one
an
else.
organized
They're stuck
rebellion.
here.
That is what the Supreme Court says in the prize cases, and I agree with it.
And the prize cases were cases that came up during the Civil War where the Supreme Court said just that, right?
Said,
Where the Supreme Court said that an insurrection need
yes.
not rise to the level of a rebellion.
yes,
And
For a long time
insurrection
now.
also need not rise to the level of a civil war. Is that right?
yes.
I got 872 people watching me on Rumble now.
You're not saying that a criminal conviction or a guilty plea on a charge of insurrection is a necessary condition for a Section 3 disqualification.
No,
If you can like
On
and
direct
subscribe, by
examination,
the
when
way,
you were talking
Rumble
about
folk,
the president's oath
YouTube
versus
folk,
an oath to support
I'd be
the
obliged.
Constitution,
thanks.
you said that the drafters of the Constitution were very careful with their words. Is that right?
yes.
Is it your testimony that they were so careful with their words that they used a term insurrection that just had no clear meaning?
Can I follow? I don't understand. Could you repeat it?
Well, you testified that the framers were careful with their words.
Yes,
But you've also testified that insurrection is a sufficiently unclear term that we need Congress to tell us what it means. Is that right?
did I testify to that? I don't remember, but I think I probably did, yes. Certainly that congressional guidance would be helpful, instructive to the courts because the term is pretty broad gauged. There's also the question of whether the courts can enforce it at all without Section 5 action, but that's separate, I think, from what you asked me.
Can I just ask you to speak a little
Oh,
closer
yes,
to the mic?
the question is a bit complicated because it implicates Section 5 of the 14th Amendment as well as Section 3.
And other provisions of the 14th Amendment, like Section 1, also implicate
The more I
Section
look at it, the
5,
more
right?
I
Yes,
came to the conclusion like 25 years ago
Now,
about this.
if I have trouble knowing what a word means, sometimes I go to a dictionary. So let's look at some dictionaries. And
At
this
the time
is
they did it, it was
Petitioner's
legal.
Exhibit 144, the appendix of materials that we looked at with
It was made
Professor
illegal afterwards,
Magliocca.
which is ex post facto.
Page 785. I believe you testified about Webster's on direct, but we didn't look at it. Webster's in the antebellum period defined insurrection as a rising against civil or political authority, the open and active opposition of a number of persons to
Banner.
the execution of law
Look at the banner.
in a city or state, correct?
Yes.
And Webster's was not the only
Blue
dictionary
banner,
in the
white
antebellum
font,
period that
scrolling on the
defined
bottom.
insurrection in just this way, was it?
I think that Webster's definition is the essence of it, maybe not word for word, particularly execution of the law in a city or state. It was widely accepted, maybe even followed.
You cite some cases in your report as well, and I just want to pull that discussion up. Plaintiff's Exhibit 227 is your report. And if we go to page 71, there's a discussion of a Georgia Supreme Court case in 1868 called Chanceley versus Bailey. Do you see that?
Yes.
And in Chanceley versus Bailey, the year that the 14th Amendment was ratified, the Georgia Supreme Court said, if the late war had been marked merely by armed resistance of some of the citizens of the state to its laws or to the laws of the federal government, as in the cases of Massachusetts in 1789 and in Pennsylvania in 1793, it would very properly have been called an insurrection, and the acts of such insurgents would have been held as illegal, correct?
Yes.
You also testified on direct about the instructions by Justice Catron that we looked at in Professor Magliocca's testimony, and
I
you
don't think
call
that
those
helps
grand jury
petitioners.
instructions helpful in
Mhm.
understanding insurrection. Is
Yes.
that right?
Yes.
And just to make sure we're all looking at the same thing,
Yeah, the petitions are working very hard to make sure insurrection is very, very broadly defined. Because most of us,
we go a
I
few
don't call it
pages
an
in to
insurrection. I think it's kind
752
of crazy
Professor
to call it an
Magliocca's
insurrection.
appendix. Justice Catron instructed the jury that the conspiracy and the insurrection connected with it must be to the effect to affect something of a public nature concerning the United States, to overthrow the government or some department thereof, or to nullify and totally
Yeah,
hinder
but that's not what
the
Magliocca
execution
said.
of the United States
Your expert
law
didn't
or
say that.
Constitution, or some part thereof, or to compel its abrogation, repeal, modification, or change by a resort to violence. That was the instruction that you found helpful, correct?
Yes.
Did you also look at how Justice Chase, not the Chief Justice, the other Justice Chase, defined insurrection in the case of Fries?
No.
We go to page 834 of Professor Magliocca's appendix. This is a case of Fries from the Circuit Court of the District of Pennsylvania in 1800. Do you see that?
Yes.
If we go to page 841, the court says, on this general position, the courts are of the opinion that any such insurrection or rising to resist or prevent by force or violence the execution of any statute of the United States for levying or collecting taxes, duties, imposts, or excises, or for calling forth the militia to execute the laws of the Union, or for any other object of a general nature or national concern under any pretense as that the statute was unjust, burdensome, oppressive, or unconstitutional, is a levying war against the United States within the contemplation and construction of the Constitution, correct?
Yes.
And that also uses this language we've seen earlier about a rising up to resist by force or violence the execution of law, correct?
Yes.
I just want to finish this line of questioning by asking about your example where you say that Professor Magliocca's definition of insurrection against the Constitution would essentially mean that Section 3 covers any effort to obstruct the mail. Do you remember that testimony?
Yes.
Well, that's your interpretation. That's not something Professor Magliocca ever testified about, correct?
That's right.
Do you remember that when Professor Magliocca gave his definition of insurrection, his definition was a group of persons resisting execution of law by force or threat of force?
Yes.
And do you also recall that Professor Magliocca explained that Section 3 only applies to those who had previously sworn an oath in certain kinds of official capacities?
That was my recollection of his testimony, yes.
If a person has never been in government and never taken an oath to the Constitution, does Section 3 have anything to do with them at all?
No.
Well, that's a requirement under the offense element, who, having taken an oath to support the Constitution, thereafter engaged in some kind of activities.
All right, Your Honor, I think this would be a good time to break for lunch.
Agreed. We will reconvene at 1 o'clock for Mr. Heafy. And then we will finish your testimony, Professor Delahunty, after Mr. Heafy is done, okay?
Yes. May I have lunch and speak with my counsel or counsel for,
You may absolutely have lunch.
but not discuss my testimony?
Under the rules, you're not supposed to discuss your testimony with counsel.
Okay, thank you, Your Honor. Thank you.
We do want you to eat.
Okay, thank you.
Okay.
All right. Trump was president January 6th. He can't commit insurrection himself. A lot of people say that. A lot of folks say that. There's a bunch of thoughts I need to go over here. So as they go to lunch, let me mute. Those are two different words. I mean, mute everything here. Okay. Few things I need to explain about what we saw here. One of the things I said I would explain is the significance of something being of this statute being self-affecting. Self-affecting, meaning that like there's no further step that needs to be taken. That there's an argument that's the petitions are trying to make, which is this is like automatic. It's difficult to even understand philosophically the logic of this. And the Minnesota Supreme Court yesterday seemed to be trying to wrap their heads around this. And I was getting very frustrated when I was reviewing that on my podcast last night, because they were like, well, what makes this difference from trying to figure out if someone's a natural born citizen, which we would allow him to take some off or not. And to me, someone having served 2 terms then tries to sign up and register with the state of Nevada that they're going to run for president a 3rd term, which is in violation of the Constitution. That's self-affecting. Something can only be self-affecting if we can be reasonably confident that if any reasonable person in all 50 states across the country would come to the same conclusion that this person is invalid, ineligible to be president, then there's an option for it to be self-affecting, for it to be something that can be handled, by some clerk, because everyone's going to come to the same conclusion. We can be pretty certain that if someone can't come forward with a birth certificate showing that they were born more than 35 years ago, in that case, all 50 states, it's going to be rejected. For some states so that's why that can be self-affecting. When the language is someone has engaged in insurrection, that's kind of hard to say in today's day and age that should be self-affecting, because did they engage in insurrection? Was it an insurrection? Some people claim it is. I will never come to a conclusion that was an insurrection. I can't imagine a set of circumstances where I'll ever change my mind on that, because to me, an insurrection needs to have some sort of level of coordination behind it. and is clearly lacking there. And that's why I always refer to it as the siege of the Capitol. It was wrong. They shouldn't have gone in there. It was a siege. It was not an insurrection. That's my personal opinion on that. I understand that several of you in the chat, especially who've been in the chat over the last week or so, disagree with me on that. That's your perspective on it. But the point is, there are two perspectives. It's not like this guy is 35 or he's not 35, which there's no two reasonable perspectives on that. There are two reasonable perspectives as to whether or not there's an insurrection. There are reasonable perspectives as to whether incitement is engaging or is it not engaging. There are, to me, unreasonable perspectives that he actually was guilty, whether he was engaged in inciting, considering that under the Brandenburg standard, it has to be immediate in time. So for all of these reasons, when you have this convoluted different perspectives, which in one state they might come to conclusion that John Smith is ineligible, and another one they'll say no, John Smith is perfectly eligible. That cannot be self-affecting, because what that means is that when we have our secretaries of state and all 50 states are trying to figure out, well, is this self-affecting or not, they're going to come to different conclusions. How can that possibly be? That's not logical. Now, someone might come back to me and say this. Someone from the petitioner side might try to argue this. I want to share with you what their perspective is. Say, no, it should be self-affecting. You know why it's self-affecting? Because when they first applied it, it had to have been self-affecting. It was covering to large swaths of Southerners. They didn't go on a case-by-case basis and say, is this guy out? Is it anyone who had served anyone who had sworn an oath, anyone who was an officer or a senator or a member of the House or elector who then signed up to join the Confederacy was automatically, boom, knocked out. Automatically, boom, knocked out, presumably. So it seems historically. So when this amendment first kicked in, you might say, well, probably was self-affecting. And then there was a whole pardoning where there was mass pardons for all the people who this may have otherwise applied to. And then there was a specific pardon to Jefferson Davis, the leader of the Confederacy. But the point being, there was no real adjudication saying that those people there was just, this thing was written and then boom, it applied to all these different people. There's a huge distinction there, because the nature of why this was written was specifically for the Southerners who engaged in this, who had sworn an oath and then violated it. Now, does this statute even last any longer? Or was it purely meant for the uprising of the South? Was it purely meant to keep out those people who were just shooting at us a year ago, 2 years ago, 3 years ago, from being able to, well, when they were technically a senator, they were shooting at our sons, our sons and nephews on the front lines in Gettysburg, Antietam, or Vicksburg, all these different places, that they were leading charges against our troops, that we don't want them now serving in Congress. Does that still apply 100 years after all of them are dead? Well, the argument that it should still apply after all of them are dead makes sense, because they didn't just make it a statute. They made an amendment to the Constitution. They included an amendment to the Constitution. That's far more significant than some congressional statute. So when they have it as an amendment to the Constitution, that's implying a perspective that this set of rules should be for America's future going forward a long way, on generations, unless and until some new Congress passes a new amendment that repeals it in whole or in part. So to me, I do think that it's reasonable to say that this section was intended to apply for generations until such time as this is repealed. However, I do not think it's reasonable to say that even if it was self-effectuating with respect to the Civil War, that means that same section should be read as being self-effectuating with respect to future generations, future uprisings. Because it's clearly something that can, the idea to having an amendment in the Constitution is that it has to be something that can be understood and applied appropriately. It has to be something that we all can understand what's going to happen with it. And seeing as how and that there's going to be uniformity. We're trying to figure out whether someone is going to be serving as president of the United States. And assuming this applies to the president of the United States, which that itself is an issue, is at issue in this case. So to start saying that we're going to have a Secretary of State from the state of Nevada arguing with the one from Texas, who's arguing with the one from Maine, who's arguing with the one from Hawaii, is ridiculous. How can you possibly, how is that not a recipe for a banana republic? How is that not a recipe for disaster? That in one state, this candidate will be allowed, in another state, he's not. And that it doesn't make sense that that's what the not framers, but the framers of this amendment, the authors of this amendment, had in mind. So while they may have globally understood it to be applying to as a self-affecting method for those who participate in the Civil War, to think that they were so stupid as to think that, like, oh yeah, if there's some conflict, we're going to have Professors Magliocca and Delahunty arguing about what is an insurrection, and that if you decide that this is an insurrection, then anyone who has in any way knows people in the insurrection, gave aid or comfort, loaned them $20, that person now, we're going to have self-effectuating that a Secretary of State will say, well, sorry, Jim Banks, you gave $20 to this guy who was taking a bus to Washington and later ended up shooting, and then later ended up strolling around the Capitol. So now I think that you're aiding and giving aid and comfort to someone who's participating in an insurrection. So you're out, you're off. It's so stupid. That's not the way any country can actually operate. No one can actually make that kind of argument in good faith. And similarly, with respect to the whole incitement issue, as far as is inciting engaging, is it not engaging, all that other stuff, I think the petitioners here have a real problem. I think they have a real problem. And these are many of the reasons that I feel very, very confident. Someone sent me a super chat earlier. I said, I'll address this during a break. They asked me, why am I so confident that Trump is going to be on the ballot? And I am 100%. I cannot tell you how astonished I would be if he is not on the ballot in 2024. Because the Supreme Court has three different wings to the Supreme Court. There are three different perspectives on the Supreme Court. You have the left, which is Ketanji Brown Jackson and Sotomayor, Kagan. They are consistently going to side with the left. You have the right, which is Alito and Thomas, usually Gorsuch, who are fairly reliable, certainly two of them, if not all three of them, that they're going to lean conservative. And then you have the three who are considered part of the conservative supermajority, but are not really conservative. They were appointed by Republicans. But when you're looking at Chief Justice Roberts or Amy Coney Barrett or Kavanaugh, and you look at the way they decided cases since their appointment, they seem to be very strongly neocons, and then different from a MAGA perspective. I do not think they like Trump, even though 2 out of 3 of them were appointed by him. And I think that they are very strong believers in the importance of our foundations of our country and maintaining our republic in the way that it was established. And I think that's what governs them. And I think that they feel as if, like, maintaining respect for the power of the federal government is important. It's a very neocon perspective, very anti-MAGA. And I think that they think that the importance of maintaining the strength of our Department of Health. This is why they came to conclusions they came during in 2020 and 2021 when there were issues as far as mandates and things of that nature. Because like, no, we have to trust government, big brother, very 1980s Republican type of perspective, rather than the 2023 MAGA type of perspective of the importance of individual liberties. So even though I don't think that they like Trump on a personal level, I think they hold their nose when they see him. I think that they do have the arrogance and hubris of your classic government bigwig politician, gross, disgusting, who both the left and right can't stand. When I say left and right, I mean the MAGA division, I mean the more progressive division of the left. They are very strong about maintaining a strong America. What will help keep America strong? And for that perspective, I think that they are sufficiently intelligent, because I do think that those three are really intelligent. Certainly two out of three of them. I think that they are almost certainly going to say we cannot have a republic where we're going to have some clerk in some state deciding who's going to be on the ballot, who's not. They might set down certain guidelines and say, when we're interpreting, so that's why I'm thinking, if any of these states actually go against Trump and say, yeah, the Secretary of State has the power to take Trump off the ballot, I cannot imagine they're going to let that stand, not because they like Trump, but because the natural ramification of that is 5 years, that 4 years from now, 8 years from now, 12 years from now, 16, 30 years, 32 years from now, we're going to have the same issues coming up with someone else. And it's going to be set down now that all these individuals, whatever idiot bozo is handling this, has the ability to basically say, I don't like this guy, I'm not letting him in here, and justifying it with some sort of empty reason. So they're going to have to lay down some groundwork as to, like, how do we reach a determination as to who's ineligible under Section 3 of the 14th Amendment. And accordingly, I think we can be pretty confident that when all is said and done, you're going to have a determination by a court that this person has engaged in insurrection in order for them to be kept off of the ballot. And this is part of the reason that I think that it's that Trump's attorneys in both Minnesota and in Colorado are making a little bit of a mistake by fixating that only Congress has the power to decide who this amendment applies to, who this section of the 14th Amendment applies to. It's a very weak argument. And I said before, I think this is a weak argument. I don't like the strength of this argument for a bunch of reasons. The reason I don't like it because A, there are other parts of the 14th Amendment, and I brought it up there. Section 5 of the 14th Amendment says that Congress shall have the power to pass whatever legislation is necessary in order to keep the 14th Amendment operating appropriately. Okay, fine. It's a weird clause to put in there. I think it's enabling them. It's not limiting the judicial branch. It's not limiting the judiciary from stepping in and interpreting the 14th Amendment or how it applies or what it really means. And that's the read that it sounds like Trump's attorneys are trying to apply to it. And it doesn't really make sense to me, because we do see the 14th Amendment with respect to subjective due process and other sections of the 14th Amendment that have been interpreted by the Supreme Court and other branches of the judiciary thousands of times over the last 150 years. So why is it Section 3 would be different from Section 1 of the 14th Amendment? So when we're looking at what Section 5 is doing, it does not seem that the court has at any time ever said, we have to stay out of here because Section 5 of the 14th Amendment. I don't think that they would respect that. I think they think Marbury v. Madison would overturn that anyway. And I don't think that they accept that. And that's why I don't think this argument is a compelling argument to make to a judge, because the judge is going to be like, no, that's not what's happened in the past. And even though we haven't dealt with Section 3 of the 14th Amendment, I have seen it with Section 1, Section 2 of the 14th Amendment. So I'm not buying that only Congress can decide what this means here. And it seems as if this judge was rejecting it. And on that score, I happen to agree with her. It's just not, and it's not a strong argument given what your audience is to say you don't have the right to listen to this. You're walking in losing. And even if you were technically accurate, which I don't think you are, given historically how this has been addressed, even if you were technically accurate, the person you're pitching it to there is the last person on earth who's likely to accept that as being something that's binding on them. So that's why I think it's a poor approach. The idea, as strategically as an attorney, I think it's a poor approach by his attorneys to be taking this tack in both Minnesota and in Colorado. Because I think it's a loser. It's even if you're technically right, you're not going to win with that argument in court. So why would you present an argument that you can fully expect that the judge who's overseeing your case is going to say, I'm not accepting that argument. So this is why I'm saying tactically it's a poor move, even if it's technically accurate. And I'm not even sure it's technically accurate. My opinion is it's probably not technically accurate. I think that the Section 5 of the 14th Amendment is simply empowering Congress to take further steps and sort of impart a type of constitutional strength to those steps that they take. But not that it's actually limiting the judiciary, saying judiciary can't weigh in here. However, what I do think is where the judiciary is limited is that I don't think that the judiciary can also empower the executive branch to start taking different things. I think they have a right to interpret the Section 3. But what makes the most sense is what I was trying to explain last night on my podcast. That what Section 3 does is this. What is it actually doing? Let's not lose sight of the forest because there's all these trees here. Okay? There are 8 billion humans on the planet. Which of them are eligible to be president? Well, the Constitution lays out you have to be a natural born citizen, you have to be over 35 years of age, and you have to be living in this country for 14 years. Okay, fine. Once any individual can establish those 3 criteria, they are now eligible under the Constitution to run for president. Anyone. Can they lose that eligibility? Yes. How can you lose that eligibility? Well, you can lose that eligibility if once you can establish that by a reasonable standard, now you move from this class of people who are ineligible, who don't have those 3, into this group of people who are eligible and can be president. That to me is the most logical way to understand the Constitution. It's basic, it's simple. All these people here, some people are in the group that are missing one of those 3 elements, and the rest of us fall into that category of we are now eligible. They might be missing it because they're too young. They might be missing it because they were born in the wrong country. They might be missing it because they moved away and they haven't been living here for the last 3. They weren't living here 5 years ago. Any of those bases, they're now ineligible. Okay, but once someone establishes he or she is in the class of people that is eligible, now the onus falls on other people to establish that there's some disability in their eligibility that makes them otherwise ineligible, that takes them out of this group from the status quo of you're eligible into being something that you're no longer eligible, like incapacity. You don't have sufficient capacity. Your brain, you're Biden-esque in your thinking. Like you engaged in treason or some other, crime that you were convicted of. But if you're going to take someone out of this established class of people who are eligible, the people who are eligible, and you want to pluck someone out and say, not you, then the onus comes onto the parties who are saying, not you. Now, clearly, Trump did fall into this class of people who were eligible. That's why he's able to serve, right? So he covered those 3. Now you want to pluck him out of there. Now the onus falls on you to prove it. To say something is self-effectuating is ridiculous to someone who's already established themselves as being in here. You want to remove them? I don't think you have to have a congressional act to remove them, but I do think that there has to be some sort of conviction beyond a reasonable doubt before a jury of your peers that this person engaged in insurrection, rebellion, or whatever. There has to be some sort of determination, not by preponderance of the evidence, not by some sort of thought process of like, well, this guy doesn't like them, or a lot of people don't like them, or these people who are really Ivy League scholars really don't like him. Lawrence Tribe doesn't like him, and Robert De Niro is saying, F you, Trump, therefore he thinks he's an insurrectionist. Therefore, now that empowers the secretary. It's ridiculous. There has to be an adjudication, due process, an ability for him to defend himself. And that's just basic. Why? Because they felt because he's one of several hundred million people who fall into the class of eligible to be president of the United States. You want to pluck him out, get an adjudication that gets him out. Now, that's why I think Trump's team would have a much stronger argument in court. Minnesota, Colorado, they say might be going to Arizona. Much stronger point if they said, unless and until someone is adjudicated to have engaged in insurrection or rebellion, Section 3 of the 14th Amendment cannot apply to them. And that has to be adjudication in a criminal court. And perhaps if the person was president, as he was, that adjudication can only come if there was first an impeachment and a conviction by the Senate, and then followed by a conviction by a jury of his peers. You need all three if he's president. Because he has presidential power, broad immunity from all this stuff, far more so than a senator or a member of the House. It should be really hard to take out a president from being able to run for re-election. It should be really, really hard. Does that mean it's impossible? No, it should definitely be possible because the guy could, theoretically be a lunatic. I mean, Pinky in the Brain style lunatic. And I know a lot of people on the left think he's a lunatic, but I don't mean like that. I mean, actually like a crazy person who, basically you're like, this guy is trying to destroy our own country. And like I said, I know a lot of the harpies on the left will apply that to Trump. But even so, fine. If that's what you think, that's your opinion, then get an adjudication in court first. And if he's president, it should be, if he's that crazy, if he's really that crazy, there will be an impeachment. There will be a conviction and by the Senate, and there will be a removal. There will be a court adjudication. And at that point, the person should lose their eligibility and say, oh, Section 3 of the 14th Amendment says you can't engage in that after you made an oath and to the Constitution that you're going to uphold the Constitution. And accordingly, that's when it would be logical to apply it. That, to me, is a much stronger argument for his counsel to make to these judges, because these judges are not going to hear, oh, we're not empowered, only Congress is empowered. They're not going to accept that. And there's a lot of reasons for them to reject it. Most notably, that historically they've never accepted that argument with respect to other elements of the 14th Amendment. So that's why, in a nutshell, I say to you, I present with Trump's stronger arguments that his counsel's really not been making in either jurisdiction. Quite the contrary, they sort of try and keep saying, court, you can't listen. That's why I think that they're making tactically an error. Despite that error, because of the makeup of the Supreme Court, I think we'd be really, really confident. Like, I would be shocked if it's like shocked if the Supreme Court allows any of these states to keep him off the ballot. Some of you have asked about the ability to write him in. I can't tell you about that. And I actually think that he probably would get tens of millions of votes. I think he would get easily like 40 million votes as a write-in in the 2024 election. I don't know whether these states are obligated to accept it. They probably say beforehand, we're going to reject it. Even if they said they'll reject it, if every state said we're rejecting, they still would get 5 million write-ins on Trump for 20. The dude could, God forbid, drop dead a month beforehand, and I still think he'll get 5 million votes. That's how strong his support is right now. That's reality. Now, just as far as wrapping up the week here, okay? Wrapping up and letting you know, I'll let you know this. I started this saying the judge should recuse herself and that she's biased. I've watched her work all week long. And I've been watching her very carefully. I've been watching counsel for both sides. I've been watching witnesses for both sides. I've been watching coming to my own independent assessment as to the credibility and how believable these folks sound and likely are being accepted or rejected by this judge. I think the judge probably is a strong lefty, not simply because of the fact that she's a white woman living in Denver, which tips us off to that's probably a start to thinking that, a rich white woman living in Denver, who's part of the whole Ivy League and sufficiently connected that she can become a judge in a Democratic city. I'm fairly confident that you got to be pretty strongly liberal. But then you had the whole issue. They tried getting her to recuse herself because she's donating money to an agency that is dedicated towards censuring the Colorado GOP for allowing Trump to participate in the 2024 election or whatever, which is why she should have recused herself. Now, she said she doesn't remember anything about that donation, and I'm sure she has a lot of money. She's working for Ballot Spar for 20 years or 10 years, whatever. If she's Ballot Spar, I'm sure is paying her $500,000 a year. At least. So I'm sure she has a lot of money. Okay. And that's another sign of someone who's part of the whole Ivy League elitist thing. And I'm sure that when she donated $100 to this agency, it's very possible that any idiot called her up on the phone and she didn't even know she was what the agency was about. She's like, all right, here's $100. She didn't care. She didn't think about it. Okay. It's very, very possible. It's very possible. Do I know that's what happened? No, I don't. She could be making up stuff. I'll tell you that I think she started very strongly in the camp of, I want this case, and that should be disconcerting. This should have gone to federal court. We see here how during this whole dialogue that we're basically looking at in issues, so many issues of first impression. Federal court is designed to handle how do we interpret federal statutes or U.S. constitutional amendments. And this is something which has never been addressed anywhere before. And you're coming in here as a state court judge who got your job less than a year ago and saying, oh yeah, it's my place totally to be the first person on the planet to weigh in as to what this amendment, this section of the 14th Amendment means. That is remarkable hubris. That is arrogance. That is ridiculous. It's ridiculous. It's not even like you're trying to take federal law and apply it to your state. You're trying to write what the federal law is. That to me is ridiculous. The Minnesota Supreme Court is at least the highest court in that state. So maybe they feel they have sufficient place to do that. I don't know. But what I will tell you is that so when she's determined to keep this case and she's donating money to organizations like that, should we have concerns that she's in the tank for the petitioners? Yes, you'd have to be blind to not have those concerns. However, at the same time, I've watched her all week and she made a few determinations that I was like, man, that's terrible. That was just like, that's really leaning hard. That's really leaning hard. I thought that this should be knocked out on First Amendment issues. They have to overcome the Brandenburg standard and establish that what he's doing here, that's a First Amendment issue. And that everything that he said, and there's also presidential privilege issues. I think these state courts, a lot of these judges are flying out of their lane because they want to be involved in the whole national story of what's happening with Trump, and I think that they look at it as a chance for political acclaim. I think we have to certainly be very suspicious of it when there's so many reasons to think that this should not be in your jurisdiction, and yet you're asserting your jurisdiction and refusing to recuse yourself. That's a very sus position to take. I will tell you that the nature of how she engaged with the witnesses, specifically the defense witnesses, whether we're talking about Kash Patel, whether we're talking about this expert witness today, it was a more open listening type of perspective. And I think that in her own mind, whether it's true or not, I think in her own mind, she believes she's being fair. I don't think she realizes. I don't think she's one of those evil people like Nancy Pelosi is like, yeah, of course, this is all showing games for the public, but we all know that. I know what I'm doing. Like the Hillary Clintons, like the Chuck Schumers, like the Mitch McConnells and the Ken McCarthys. Everyone, that's the unipart. That's both sides of the aisle. So I think that she doesn't look at it that way. I think she actually thinks she's being fair. I think that she's very heavily tilted while believing that she's being fair, and doesn't realize that how cloudy her own vision is. That's my personal take on her. I don't know her personally. I never heard of her before this week. I'm simply telling you that's my personal take just from watching her and seeing how she's engaging. I think she's trying to be fair, and I think that she started from such a position of bias that it's hard to believe that she'll ever extricate herself from that. And I think that she's trying to figure out what she's supposed to do. And I think she's also afraid of getting it wrong, which might motivate her towards actually being open to like thinking about all the problems that the petitioners have with their hopes for getting the relief that they're seeking here. I think that some of the witnesses, I think today's witness was kind of boring, kind of helpful. He actually looked better to me on cross-examination than he looked on direct. And he gives alternative perspective to Magliocca. I think she gave a lot of credit to Magliocca. Just based on the way she was questioning Delahunty, it seemed as if she actually felt Magliocca made some real points, and she wants to see how you knocking those points off. And I don't know that he was effective in doing that. So, yeah, that's my take on all of that. That's my take on all of that. Debbie sent locals, which is goodlogic.locals.com. That's goodlogic.locals.com. A long time ago said the lawyer EO who docks the person may be affiliated with or was affiliated with the law firm that is representing the plaintiffs or Griswold. I'm not sure. AE has a link to her court docs. I'm not sure who AE is. On Twitter, oh, Ashley in America. Coincidence? Monitoring her spying. Very scary times. May God bless you and your family. Also saying the person they doxed during the trial, AE, has a complaint filed against her. Oh, that's Ashley. Oh, Ashley. Oh, okay. So we're talking about Ashley has a complaint filed against her in March of 2022. Count 1, intimidating voters. Count 2, attempting to intimidate voters. Count 3, violation of the KKK Act. Jenna Griswold, Secretary of State of Colorado, is listed as a witness for the plaintiffs in the final pretrial order field, May 2023. That came first. The lawyer EO who docks the person may be affiliated with the law firm that is representing the plaintiffs of Griswold. I'm not sure. Ashley has a link to her court docs on Twitter. Ash in America. So that's maybe that there's an ongoing fight there. Maybe that this was never about me or even Bannon and his war room streaming it, but this was much more about AE and a personal fight that's going on there between Ashley and the petitioners. Very possibly the case. Very, very possibly the case. It would actually be very logical to me if that is part of the issue that's going on here. Thank you for enlightening me on that, Debbie. I appreciate that. I had no idea. I just want to make sure I didn't miss anything on Rumble and catch up on some of these things here also. David Bowser says this lawyer wants insurrection defined so broadly that simply resisting arrest by a police officer would be called an insurrection. Yeah, he wants it. That's what's the name, Maglia wants it like that. Does the doctrine of lenity apply to the Constitution? If so, any ambiguity should be resolved in favor of the candidate. Thanks for your great coverage. Yes, but one would say potentially that this is not criminal. So doctrine of lenity is basically, or the rule of lenity is a concept that if something is ambiguous, you have to rule it in favor of the defendant. If any of this statute or it could be read one of two ways, whichever way is most beneficial to the defendant is how you must read it. That's what Tom Forsyth is asking here, and yes, I just don't know if the rule of lenity only applies to criminal, and I don't know if this is considered criminal. But it's a good thought. It's a good thought that I think I mentioned a few days ago, but I haven't mentioned in a few days. I'm glad you brought it up, Tom. Thank you. Chase says, random question. Small Wisconsin case. Guy threatened or hit cop, felony. Odds of getting 6 years in prison. Curious what will happen to this. No, there's no way I could weigh in on that. On a specific case, which I had never heard anything about. I have no, and I also don't do criminal defense, so I don't know. Okay, Joe Montana. That's going to be my new nickname, Joe Montana. I always thought he was overrated. Also, there's a witness statement that the guy threatened to shoot her right before he was arrested down the street from her. Dude, Chase, what are you asking me to weigh in on some case? I don't even know the name of the case, the name of the party, and I'm not a criminal defense attorney. I'm not even going to try. I can't. They already tried a congressional act. It was impeachment, and it failed. And I agree with you. To me, that should be the end of it. That should be the end of it. How much does the judge's ego aversion to getting over to my scores weigh into all this? It probably depends. It probably varies significantly from one judge to another. And I think the younger they are as a judge, the newer they are as a judge, you would imagine the more concerned they are about being overturned. You know, I've been in court for a year and like I'm being overturned on this national stage. That's kind of more embarrassing, you would think. But anyone who says they know how much that would be affecting her is purely speculating. Kelly! These liberals have been concise in their beliefs and implemented her for a reason. Just like that Carroll's judge. Yeah, Eugene Carroll. In New York, my sister is a radical Denver lib, and I know firsthand they have thought this out 2 years ago. It's very possible. I don't know how they assign judges. It's very possible. It's very possible. She's realizing just how big this is. It's possible too. It's possible, carrying through on the plan is not easy. If you want to find out when and where I am, you need to sign up on Locals. I appreciate if you like and subscribe and drop a comment down below. Tell me what you think about my assessment of this case before I give you like where we're heading at now. So I really appreciate if you could drop a comment and tell me what you think about my assessment. If you disagree with any of my assessments, whether it's my assessment as to the strategy that Trump's team is using or whomever, let me know. I'd love to hear your thoughts on it. I think that and I'll give a further assessment as to what I think of each of the players here. To me, it hands down, Scott, the lead counsel for Trump is the best attorney in the room. The former Secretary of State. He's great. He's been great. Today's witness, who he was doing direct on, is a very tough witness for a few reasons. It's a boring topic to most people. It may not be boring to the judge, because this is the sort of thing that people who get who make the law their lives, they actually care about the philosophical. And he has a sleep-inducing voice, and there's a lot of ums. So I understand, but as far as it doesn't make for riveting testimony. It's not going to. He also is not compelling as far as saying this is definitely what's right. He's like, this is why I think Maglia is wrong, but what the flaws in his read. He's like, we don't know, and his whole position is we don't know until Congress tells us. That's not an affirmative. I'm telling you, this is what's right. So it's a more passive type of objective in the testimony. It's hard to make that compelling. I do wish they got Dershowitz, which one of my viewers suggested what they needed. Anyway, so that's my thought. I think he was easily the best one. The guy who sat second chair was to me the worst of the bunch. I thought he was terrible. I mean, not terrible. That's too strong. I thought he was. I'll call him mediocre. I'll give him like a 4.5. A scale of 1 to 10. I give him a 4.5. It's just like he seemed confused too often. And disorganized. He plotted through some of the parts there, but every time he got up there the biggest flaw I have with everyone from Trump's team is I don't think they object nearly enough. I think they need to object a lot more than they did. Like a lot more than they did. On the defense side, while Kash Patel smacked around that attorney in that cross-examination, I think that they've been consistently okay. I get confused between all of them. Aside from Quakey Voice, and I don't know any of their names. Aside from Quakey Voice, I can't really tell them apart. I think there's 3 of them. That guy who is doing cross-examination now, my God, he sounds arrogant and snotty. Like there's a certain snot-nosed tone to him, which is just very. It's very moot courty. It's very like you think you're on the debate team in your high school kind of thing. And you would have to agree that Lawrence Tribe is a really well-respected professional, wouldn't you? It's like I think I just scored a really big point, even though no one really says it. But I'm talking with a tone that makes you understand that I think I just nailed you, didn't I? And Maglia, he cites Paulson, right? He's cited by Paulson, isn't he? Yeah. And Paulson, he's cited by Maglia, isn't he? Yeah. that whole little circle thing he was talking about. You're not cited by Paulson, are you? He never mentions you. Never heard Maglia mention you, did you? You see, I win. It's like, all right, I don't know who that worked on for you. Is that you get dates with that? Does that work for you? I don't know. So I wasn't very impressed by that. The police officers did what the police officers were going to do. I think that Buck was okay as a witness. I think that Ken Buck I'm sort of popping out over here. I couldn't really hear Swalwell, so I can't tell you much of what came out of that. He was so impossible to hear. He was very impossible. So I can't tell you much of what came out of that other than his telling of his narrative. I felt that the witnesses who were trying to lay out how how the overall theme was not at all a violent insurrection, but that these people who were coming down there, their objective was let's go down there and show our support and make our voices heard, but not go commit any crimes. And I think that some of the video evidence they presented for that was a healthy reminder for people on the left that this was never, none of these people here who Trump was gathering together his forces to start an insurrection, that's a ridiculous way of looking at this whole thing. And for months and months, he's sending out tweets saying, because we're gonna set this Capitol on fire. It's saying it's gonna be wild. It's like kind of ridiculous. It's kind of ridiculous when you consider all these people who are coming there. None of them heard that. I like the statement that was made by the treasurer, what's his name, Borkland, yesterday, who's like, why didn't you engage in any sort of violence? He's like, because I was under orders not to. By whom? By my president. He said, stay peaceful. That was very well. It was planned, definitely coordinated. Well played, though. I like that. It was played very, very well. Yeah, and I think that Dr. Simi, I think that the cross-examination of Simi, I'm just trying to think through the different testimonies. I think the cross-examination of Simi, that's that lead counsel for defense did, I thought it was brilliant work. I thought it was great work of just showing how anything that Trump says, it basically exposed the TDS. If he says anything that could be interpreted as being violent, you're like, this is definitely violence. He says fight. Oh, he means it fight. Why? Because his listeners, they hear fight and they understand fight. Even when they hear 1776, that means we need to kill people. If they hear snowflake, that means that means go get them, boys. Let's get out the tar, get out the feathers, and let's dump it on them. Throw them off a bridge. Because they're all just crazy out there. That's what they're all like that. They're all like that. Every one of them. And you saw the defense counsel was like, you don't believe that Biden legitimately won the election, do you? Huh? You're one of those. You're one of those. Is this a conspiracy? Is this a conspiracy? I loved how that blew up in their faces with Cash. He was great. The Cash Patel was the star of the week. It's not even close. And when you're so effective at how you're testifying that this judge who's tilted against you is laughing along with you at the other side, it's a good sign. It's a good sign. Anyway, so overall, look, do I think that he's winning this case? I think he is, but I also think the judge likely does not think that he is. I'm being realistic with you. I do not think that the judge thinks he is, but I don't know. Maybe he moved the needle on her. She was already starting all the way down in the valley over here with the valley of the petitioners. So, and I can't tell you where she's at now. I'll tell you that she thinks she's being fair. I'm convinced that she thinks she's being fair. She doesn't think of herself as being evil or stupid. She thinks she's being fair. That's what she thinks. I think her vision is very, very cloudy. That's my perspective. I think her vision is very cloudy. There's supposed to be testimony that's coming up, I think, in 10 minutes or so. You want to find me? I'm at goodlogic.locals.com. I'm a Sabbath observer. I am not going to be carrying the rest of the testimony here. You can go to C-SPAN yourselves. Check it out. You can go to WebEx yourself, check it out, and go forward. I will even, those of you who are interested in watching it, I know it's hard to find, and I'm not trying to keep it secret from you at all. So what I'll do is I will put in the description down below links where you can link in to watch on WebEx or on C-SPAN. I warn you, if you're watching on C-SPAN, the audio and video may not be synced. You saw how we struggle with that. So I will share those. I will share that links and put them in my descriptions both on Rumble and on YouTube. And that'll go on the description of this video here. On Monday, I'm not going to be streaming today. If this trial resumes Monday morning, I have a court appearance that I need to make Monday morning. We don't know when this is resuming. There's definitely not going to be closing arguments now. So I just want you to be aware, I'm not going to be here Monday morning. If court is still ongoing Monday afternoon, which it likely will be, I expect to be resuming my trial coverage at that time. But I do not expect to be here Monday morning. So I wanted to give you that heads up on that. I do plan on streaming tomorrow evening at Saturday night, probably late at night, like midnight Eastern time or 10 p.m. over here in Montana. Usually around then, and Sunday as well. But Monday morning, when I will not be able to cover this on Monday morning because I have a client that I need to make an appearance for. I'm going to take care of that. That is my story. That's my show. I'm wrapping up over here. Please like, subscribe, do all that good stuff. Oh, a couple last things here. Going to ask the important question here. Sunday, will Cowboys dominate the Eagles? They're not, I don't know if they're going to dominate, but I think they're going to win. I'm confused by why this judge is bothering with live expert testimony on a purely legal issue. If I'm trying to examine legal and historical interpretation, live testimony is pretty useless. I think the reason that she's doing it is she's trying to better understand. I think it's a mistake. It doesn't make any sense. Nothing that she's doing. I think she's like, give me testimony about historically how this was handled. The Supreme Court of the United States, when they're doing stuff, they don't take testimony from people and they assess how it was handled. They rely on papers. I agree with you. It's weird. It's a weird thing, Margot Rana. What's the end game with trials? Supreme will shut them down, delay, hinder, greater plan, beta real insurrection. I think they're going to win. I think they think they're going to succeed. I think that's why they do it. I really think they think that, oh yeah, we got this. Oh, there was another Rumble rant that popped in. Ash in America is also streaming the live feed on Badlands Media Rumble. Oh, okay. Appreciate you sharing that. I'm going to modify my description. I just got to find the link here that I was using a few days ago and not at all today. Where was it? It was over here. All right. C-SPAN is just cspan.org. And you'll find links there on cspan.org. If you want the WebEx, so here, description. C-SPAN keeps making different links. I can't give you their link. Okay. Right above the links from my channel is now there for you. What? Yeah, it's there for you now on both Rumble and YouTube. So you can find it there. You can check it out. I hope you have a phenomenal weekend. I thank you for joining me and your participation. It's great. And those of you who just sat and watched, I really appreciate you. Those who were able to contribute and participate in other more involved ways, I thank you very much. And please, please, please make sure you like and subscribe. It's really big to me. This is how I grow. So please make sure you like and subscribe. And I will see you all, God willing, on Saturday night. Till then, have a phenomenal weekend. Look out for your loved ones. Relax. Get away from this political nonsense. Have a good time. Be happy. Eat some bugs. Godspeed.